is just the territorial jurisdiction. So we wanted this particular law to be applicable throughout India, since it's not just the manufacturers of one state, but manufacturers of entire India.
So if a High Court strikes down the legislation as being violative, that striking down will have effect only within that state and not all over the country?
Yes, Your Lordship. For example, in the recent hijab issue, it was restricted only to Karnataka, and that's why...
in the case that you just quoted, was the legislation challenged? Was the legislation challenged?
Lordship, the council gave this example as even there it was regarding the fundamental rights.
What was under challenge there?
The freedom of religion, Your Lordship.
What was under challenge?
The freedom to profess and practice religion, the fundamental rights.
In this case, you're challenging a piece of legislation, isn't it?
Yes, Your Lordship.
Proceed.
Lordships, it's submitted before this court that the petitioners are firstly complying with the ASCII code and abiding by the regulations put up by the same. And further, they were also complying with the regulations put up by the CTN rules. As you all know, my Lordship, that marketing in today's world is very important. Marketing is necessary to create awareness, increase sales, and sustain in the market. Surrogate advertising helps to keep the brand name alive in the minds of consumers. Without surrogate marketing, they would have no existence in the market at all, and this would likely put them out of business. The most important function of a surrogate advertisement is that of a brand recall. Your Lordship, the first submission is that commercial advertisements cannot be denied the protection under Article 19(1)(a). The Supreme Court in Indian Express Newspapers Limited versus Union of India stated that we are of the view that all commercial advertisement cannot be denied the protection of Article 19(1)(a) of the Constitution just because they are issued by businessmen. Your Lordship, in the present case as well, the petitioner's right to advertise cannot be denied the protection under Article 19(1)(a) just because they are businessmen. Your Lordship, it is only through advertising a consumer would remember about a particular brand. The petitioners here can't directly advertise their alcoholic products or tobacco products in the market. And so the only way they can make a consumer know that even they are selling those products is through brand extensions. And Your Lordship, in today's competitive market, it becomes very necessary for any product or a brand to survive in the market. Moreover, the chances of counterfeit products would also increase. And this would also affect indirectly the rights of the petitioners. Your Lordship, the important point to be noted here is that incomplete or curtailed information would do more harm than however important a restriction is. In fact, the more harmful the product is, the higher a need arises for accurate and full-fledged information. And in absence of that, the consumers who want to buy an alcoholic product would anyways buy the product, but they would fail to distinguish between the varying qualities of the products. That too, Your Lordship, in the given case, the matter is about liquor and tobacco and not just of any random product. For example, without proper knowledge, the actual tobacco brand and the counterfeit item that is illegally being sold would be difficult to be differentiated by their consumer. Your Lordship, illicit liquor is a matter of concern in today's market. Illicit liquor is often contaminated with deadly methanol and are thought to be responsible for hundreds of deaths each year in India. A large percentage of alcohol consumed in the country is estimated to come from illicit source. If the Lordships would permit, the Council would like to submit a fact sheet regarding illicit liquor. Yes, Your Lordship. Your Lordship, the removal of the two provisos here would increase this particular problem, as without advertising the brand name, the consumers wouldn't know the brands available in the market and they could end up buying these counterfeit products. And the businessmen who have rightfully got a license to deal with tobacco and liquor from the government, and they're even paying taxes to them, would lose out on their sales. Your Lordship, what the Council wants to confer here is that the state can't really stop a person from consuming liquor or tobacco, as the state doesn't have any right, or the state cannot dictate what a person will eat or he will drink, has said in the case of Confederation of Indian Alcoholic Beverage Companies and others versus the state of Bihar. It's mentioned in page number 19, para 30 of the memorial, Your Lordship. This, your lordship, the petitioners here are not inducing the people to consume liquor, but they are rather only contending that when a person who has already thought in his mind that he is going to consume liquor should choose their product and not other brands. This, your lordship, increasing sales and marketing profit is the very essential of any business. The second submission is that...
Are you trying to say that you want to advertise in alcohol and cigarettes? Is
Lord,
that your case?
lordship...
You don't have a fundamental right to indulge in this business.
yes, your
I'm
lordship.
trying to say that you have a right to conduct this business.
Lordship,
It cannot be curtailed by the government.
Lordship, the council is not telling that the petitioners have a fundamental right. The only thing we're telling that due to this amendment, that is due to the removal of these two provisos, the brands which are also having another product, for example, Kingfisher has a beer product and also a water bottle. So because of this, it is not even able to promote its water bottle.
Yes.
So that is the contention, your lordship.
That has not been the path of your argument hitherto addressed.
Yes.
You used the words like, say, in order to make the consumers remember your brand name and for the brand extension, and more importantly to avoid the spurious and illicit liquors floating in the market. Say, the proviso that has been provided to earlier has to be maintained, and surrogate advertisement has to be continued or permitted. So, in the guise of surrogate advertisement, the motive behind it is boosting, canvassing, putting forth your actual liquor and tobacco products in the guise of maybe a salt or a water bottle.
Your lordship, the contention here is not of allowing the direct advertisement of alcohol or tobacco. We are only asking that even our genuine brand extensions, like your lordships mentioned, a water bottle or a salt. Suppose there is another company which is also selling a water bottle. Why are they allowed to display their water bottles freely, and why not the petitioners' products are allowed to be advertised, your lordship? This is violative of Article 14. Just because a person also has a liquor product doesn't mean that he should not be permitted to sell his water bottle as well, your lordship.
You yourself said that, say, in order to avoid the flow of illicit liquor and spurious liquor, the surrogate advertisement is required. So the very purpose, intention behind this surrogate advertisement is that not to promote or not to give people the water or the juice or the salt, but it is to push your liquor products or tobacco products to them.
Your lordship, the mention about illicit liquor was because here the petitioners are rightfully selling the liquor product. That is, they're getting license from the state itself, that is the government itself, and they're also paying taxes to them. Whereas the illicit liquors, they don't have a license, nor they are paying taxes. And this was also with the point of view of the consumers, your lordship. If a person is consuming a liquor, he should rather choose a good quality product rather than opting for illicit liquor, your lordship.
Proceed.
Much obliged. Lordship, the next submission is that the amendment is failing to achieve its sought objectives. These provisos provided a framework for companies to follow while advertising their other products. The provisos in themselves restricted the companies from advertising the substitute products in a manner as to indirectly advertise or endorse the prohibited products. This, there arises no question of whether these prohibited products are being advertised, as the answer to this is a clear negative. But due to the removal of the two provisos based on the Vatsalya committee report, there are two consequences. First, the regulatory board will not have a handbook for determining whether an advertisement is surrogate in nature or not, which will give them arbitrary power to allow and restrict advertisements at their discretion. And secondly, because of a lack of proper framework, the companies are not able to advertise their other products and other product lines under the same brand name and logo, as any such attempt will be prima facie considered as an indirect advertisement promoting the prohibited product, and such will be restricted. Your lordships,
If a manufacturer chooses to name a product the same name as of a legalized product, then he runs the risk of coming into the teeth of the law. So any advertisement obviously is presumed. The problem of illicit or spurious liquor is something different. That cannot be solved by surrogate advertising. So the question is, in a prohibited commodity, you have no right to carry on business. Then how do you extend that right to say you have a right to carry on advertising?
Your Lordship, the points raised by the council now were about the brand extension. These provisos also had a regulatory measure. They had clear details about how much the sale should be, how much the turnover should be. So anyways, even through these two provisos, only the genuine brand extensions were carried forward, and the petitioners were already complying with all these regulations, Your Lordship.
Earlier, the provisos provided that the government could regulate, correct? In the surrogate advertisements, the government could regulate. That is prior to the amendment. Now, prior to the amendment of these two provisos or deletion of these two provisos, the government could regulate these advertisements even if it was surrogate, provided these two clauses are complied with, correct?
Yes, Your Lordship.
Now the government has come to know, based on the report of this Dr. Vatsalya, that removing these two clauses or these two provisos in Regulation 7 will reduce the consumption of tobacco and alcohol products. Now your petition is based on a report submitted by Addiction Free Index.
Yes,
It
Your Lordship.
says that 30% or 30 years down the line, the tobacco and liquor industry will have to shut down. If that is a positive sign, don't you think the government is justified in removing these two provisos? Your petition is based on that report.
Yes, and the fear that after 30 years the industries would get shut down.
If you concede to the fact that consumption of alcohol, tobacco is injurious to the health of the citizens of this country, and if there is some statistics which is got by the government which says that removing these two clauses in proviso 2 or 7 has in fact impacted the health of the citizens, can that not be a foundation or the basis for the government to delete these two provisions?
Your Lordships, even the Vatsalya committee report, due to which the government had brought this amendment, mentioned about advertisement, adolescents. But Your Lordship, for the adolescents, there are clear laws which restrict the people under the age of 18 and 21 to consume alcohol and tobacco. So Your Lordship, there is no direct connection with what the committee report is stating and what the amendment has resulted in. And answering about the question of using the same brand, Your Lordship, the council would like to mention about the point of goodwill. So why would a manufacturer or a businessman change the brand name of its other products when he has already been there in the industry for long and he has a certain amount of goodwill, Your Lordship?
As a citizen of this country, can you identify any other product manufactured by Johnny Walker?
Your Lordship, the council is not aware of the...
So what do you think Johnny Walker represents?
It's suppose the council believes it's an alcoholic product.
So you identify Johnny Walker with whiskey or an alcohol. You can't think of anything else other than whiskey, correct? So if somebody advertises maybe a belt or a purse or a wallet with Johnny Walker on it, embossed on it, perhaps you will not relate, isn't it?
Lordship, this is again left to the viewer's discretion. You cannot actually control what a person thinks after looking at the advertise. Yes. So the state can't really regulate on what a person is thinking, Your Lordship. The state can't just assume that banning the advertisements of genuine brand extensions or surrogate advertisements.
There is statistics available.
Your Lordship, but in the fact sheet, the Vatsalya committee has not given any data due to which they have notified the following things. And my co-counsel is going to submit those issues before the court. Yes, Your Lordship. The next submission.
The government cannot control the thinking of individuals. But can't the government control the driving the people to think in a particular direction through these surrogate advertisement?
Yes,
Is
sir.
it not an attempt of deleting those two provisos is in that positive direction?
Your Lordship, the very reason why these two provisos were brought up in the year 2009 were to draw a fine line between what an indirect advertisement is and what a genuine brand extension is, Your Lordship. And that is the purpose these two provisos were firstly brought up. But now the government is failing to regulate its. Like it's a mistake of the government rather that they were not able to regulate what is a genuine brand extension and what is a surrogate advertisement, and therefore they're again removing these two provisos and putting the consumers as well as the manufacturers and businessmen in confusion regarding what should they actually do now, because there is the ASCII code, Your Lordship, which gives regulations regarding brand extension. So now a consumer, now a businessman is confused as to what he must follow. Should he abide by the present CTN rules or should he abide by the brand extension? So that is the confusion this particular amendment is resulting in, Your Lordship. The Council would like to further the arguments. Much obliged. Your Lordship, the next issue is that the amended rules impose unreasonable restriction. Lordship, for a restriction to be reasonable, there must be a direct and proximate nexus or is it reasonable connection between the restriction that is imposed and the object that is to be sought. The amendment in the present case has put a complete ban on surrogate advertisement as well as brand extension. The committee report also stated that the adolescents were influenced by the models and started to indulge themselves in such vices. But there arises no question of the advertisement leading to increase in the consumption of alcohol and tobacco by adolescents. As the Council earlier mentioned, there are rules restricting the consumption of alcohol to adolescents, Your Lordship.
Yes.
So the contention of the state and the committee report cannot be directly taken into consideration. Lordship, even if the contention is considered, adolescents these days are more active towards other media platforms rather than televisions. And also, Your Lordship, it's a matter of common knowledge that through the constitutional goal that is enshrined under Article 47 of the Constitution, it is a total prohibition. But the hard and unfortunate reality is that revenue from excise mainly pertains to liquor and constitutes a major part of earning by every state. So, Your Lordship, when the state permits the citizens to carry on the trade in liquor and tobacco by giving them licenses and collecting taxes, and this, it is a matter of fact, if a product is sold in the market, the buyers would anyways buy it regarding whether the advertisements are there or advertisements are not. That is, if a government is allowing the state, allowing the businessman to deal in liquor, so no matter if the advertisements are there or advertisements are not there, anyways the person will obviously go and purchase the products, Your Lordship. The removal of the surrogate advertisement and brand extensions would not have a direct and proximate connection with the object that is sought to be achieved. Your Lordship, the next submission is regarding the rules violating the rights of a trademark holder. So a trademark is an indicator of a source. That is, it will distinguish the goods and services of one enterprise from another. So a company has a right to promote its products using its brand names, brand logos, color schemes, etc.
What you're saying is just because you have a trademark, then the rules should be struck down?
No, Your Lordship. The petitioner here is just stating that why is the government targeting the genuine brand extensions? Why is it not allowing a product to be sold just because it has a product of a prohibited product? So that is why the petitioner stated the point of trademark, Your Lordship.
Suppose if you are you're taking out a surrogate advertisement of a product which also manufactures liquor. Suppose if it's a bottle of water. Now people in a party consume a bottle of water and they start dancing, giving an impression that what they have consumed is not just water but something else. How do you deal with it?
Pardon, Your Lordship, the council didn't get the reference to the example given.
Suppose you are a manufacturer of liquor.
Yes.
And you have a brand or a product that is called water. You want to advertise this bottle of water. Now in the advertisement that is shown, the people who consume water, they seem to be in a drooling way, they seem to be dancing, making merry, over a bottle of water. What does it indicate?
Your Lordship, the provisos also had the regulations regarding that. It told that the turnover advertisements were only allowed to be endorsed or telecasted if they fulfill those conditions, Your
What have
Lordship.
you mentioned in your memorials about the turnover of your product?
Your Lordship, in issue number 2, we are dealing with the pre-certification that the two provisos provided, and my co-counsel is dealing with that issue, Your Lordship.
Yes.
See, what are the grounds that you can challenge a legislation or a subordinate legislation?
It should be in conformity with the Parent Act. It should not
Then
use its excess power, Your Lordship.
that's the only ground.
Your Lordship, it should also not be ultra-virus to the Constitution, and that is the issue here. It's ultra-virus to the fundamental rights.
No, that was your first limb of the submission.
Yes, Your Lordship.
So these are only two grounds available to you?
There are, Your Lordship. My co-counsel is actually
All right.
speaking about the issues. Your Lordship, the next submission is that the amended rule violates the right to livelihood of various stakeholders of the business. Article 21 and Article 19(1)(g) read together provides the citizens that they can practice any business, trade or occupation for their livelihood. Banning advertisement means a prohibition of displaying the advertisements to the public. Banning advertisement stopped from knowing about the products and services of the business. This would directly affect the profits of the business and would also affect the right to livelihood of not just the businessmen, but the livelihood of the laborers and workers involved in the business as well. If your Lordships permit, the Council would like to present a fact sheet.
See, that argument can be extended for any line of business, even an illegal business. There will obviously a certain section of people who are dependent on that business, isn't it? I think this has already been under settled law on this.
Your
Just
Lordship,
because the consequential effect of a line of business does not entitle you to carry on the business. Even if an illegal trade, you will have a whole set of people who are dependent on that trade. And just because you say X number of families or X number of people, that is not a ground to validate the trade itself, no? Business. All right. That's it.
but Lordship, here the business is a legal business and not an illegal one. And another thing, Your Lordship, what the Council is trying to ask for is that is a balance between the fundamental rights and its limitation. So here the limitation or a restriction which is reasonable is not allowing the direct or indirect advertisements, but even not allowing the genuine brand extensions and surrogate advertisement is a restriction that the Council thinks is not a reasonable one. This, Your Lordship, the Council would like to conclude the submissions for issue number 1 by stating that while trying to impose restrictions on liquor and tobacco trade, the state must not forget the right to know of the consumers, right to freedom of speech and expression of the businessmen, right to livelihood of the workers involved in it, and also keep in mind the socio-economic benefits of the tobacco and alcohol industry. If the bench is satisfied with the arguments of issue number 1, the Council seeks permission to call co-counsel to address the further issues.
Yes.
Much.
May it please the Honorable Court. Much obliged. As Your Lordship. Much obliged. Your Lordship, the Council number 2 on the behalf of the petitioner would be dealing with the second issue, which is whether the Indus Cable Television Network Amendment Rules 2021 is ultra-virus to the Indus Cable Television Network Regulation Act 1995. Your Lordship, a delegated legislation does not fall beyond the scope of judicial review, and it is accepted by this court that...
From which page of your memorial is your written material on that?
10 page.
10. 10 is the issue, but the discussion. From which page in your memorial are
Yes,
your
sir.
submissions, is the material pertaining to your submissions?
Yes, Your Lordship.
Page 22.
19. 20.
Page 22.
Your Lordship, page 22.
22? Okay. Yes.
Your Lordship, as the Council stated, A delegated legislation does not fall beyond the scope of judicial review, and it is accepted that to decide the validity of a delegated legislation, we have to apply the test of ultra vires. In the instant case, the Cable Television Network Amendment Rules 2021 is substantively ultra vires to the Parent Act and unconstitutional to the fundamental rights, which has been addressed by my co-counsel. To prove this issue, the counsel will be giving out following arguments, Your Lordship. The first one would be that the amendment is in conflict with the Enabling Act. Your Lordship, in the instant case, the Enabling Act is the Cable Television Network Regulation Act 1995. Your Lordship, an administrative rule can be declared invalid if it is in direct conflict with any of the provisions of the Act. Conflict with an Enabling Act may also arise with the reference of the objects and purpose of the Act, Your Lordship. Deciding the objects and purpose of the Act, it will involve an assessment by this court not only of the provisions of the Act as a whole, but also the surrounding circumstances in which the Act operates, Your Lordship. Your Lordship, the object of the Cable Television Network Act in its long title states that it is an act to regulate the operation of the cable television networks in the country and for the matters connected therewith or incidental thereto. By imposing a deletion of two provisos, the central government has imposed a sense of prohibition in this law, Your Lordship. Reference can be drawn to Child Labour Regulation and Prohibition Act, where the government has imposed regulation measures to curb the practices of child labour and also completely prohibited certain circumstances in the Child Labour Act as well, Your Lordship. Your Lordship, another important aspect of this cable television network rules is in the Advertising Standard Council of India, which is referred as ASCII code, Your Lordship. It is a self-regulatory code appended to the cable television network rules, Your Lordship. Your Lordship, throughout the years, the ASCII code has got a sense of statutory flavor, and it has been recognized in this honorable court in the judgment of Common Cause versus Union of India that the ASCII code is a self-regulatory mechanism put in forth for advertising the content, Your Lordship. Your Lordship, the purpose of the ASCII code clearly states that it is to control the content of advertisement, not to hamper the sale of products which may be found offensive for whatever reason by some people, provided therefore that the advertisements for such products are not themselves offensive, there will be no ground for objection to them in the terms of code. Your Lordship, the ASCII code certainly says that the products which are found offensive or the products in this case, the alcohol or tobacco, directly advertisement of these products are not allowed. However, the brand extensions, it's been given a proper guidelines in the ASCII code, Your Lordship. And since the ASCII code is appended in the cable television network rules under Rule 7 Clause 9, it is necessary that central government make sure that the ASCII code and the said amendment is in line with each other, Your Lordship. Since the Cable Television Network Act has no means to have a committee or a board to look into the matters of regulation, and the Act in itself provides no standard, no principle, no guidelines laid down in the Parliament to guide the central government while making the rules, Your Lordship. Your Lordship, there is an overriding authority conferred upon the Union Executive, but that is not a substitute for a guidance. By using the expression to carry out the provisions of the Act, it does not lay down any standard or procedure, Your Lordship. And here, the cable television network rules has clearly not been following the ASCII code. Your Lordship, now this lays down a confusion. Since by removal of those two provisions, it says that there will be no direct or indirect advertisements of tobacco and other products. By removing the genuine brand extension concept, the section 16 of the Act says that the punishment will be given when there is no following of the provisions of the Act. Since the provisions of the Act, the people who do these advertisements can't take the umbrella of the ASCII code. Just because ASCII code has guidelines for brand extension, they cannot take this umbrella because the said Act says that if you violate the provisions of the Act, you will be punished. So the petitioners are here in the position that they cannot, even if they can do genuine brand extension in the following of ASCII.
How can you fall back upon the ASCII code when the rules itself prohibit? say that the ASCII code does not prohibit
Uh,
surrogate advertisements.
yes, Your Lordship.
We can't fall back upon because there's already the field is already occupied with the rules.
Your Lordship, the council is saying that the advertisements of tobacco and alcohol products are banned in all the mediums. Yes, Your Lordship. But in the ASCII code, they have provided the means for genuine brand extensions, which are also...
This is what I'm asking you. When the rules provide, or prior to its deletion, if the rules provided a complete ban or a regulation, how can you fall back upon the ASCII code and say that the ASCII code permitted it, so therefore this should also be permitted?
Your Lordship, the Rule 7 Clause 9 clearly says that ASCII code must be followed through through the CTN. So the CTN has an obligation to follow an ASCII as well.
Please read that if you can.
Yes, Your Lordship.
Please read.
Yes, Your Lordship. Pardon, Your Lordship, the council.
I will read for you.
Yes, Your
No advertisement which violates the code for self-regulation in advertising as adopted by the ASCII Mumbai for public exhibition in Indus from time to time shall be carried in the cable service.
Yes, Your Lordship.
Correct.
So it is...
Now, how is this applicable when the Rule 7 itself says that the surrogate advertisements will be regulated in ABCD? So you cannot fall back upon what is provided in the ASCII code.
Your Lordship, the said provisos is only limited to surrogate advertisements or products of alcohol, tobacco and everything. Whereas the ASCII code talks about genuine guidelines
Yes.
for any products which may be found offensive in the nature, Your Lordship. And Your Lordship...
See, the question is, ASCII code is a form of a code of conduct by the council. It's a professional body. But here you have a legislation. So you can't fall back on a code to say the legislation ought not to be.
Your Lordship, the
Code
ASCII...
should follow, the ASCII code should follow the legislation.
No, at best they would have said that you have to follow the
Yes.
ASCII code. That's all.
Yes, Your Lordship. The ASCII code is appended into the legislation of the Act, and Rule 7 Clause 9 also dictates
The
it.
general standards of conduct, that's all. But here surrogate is specifically dealt with in Rule 7.
Your Lordship, another submission that the Council would like to make is that the Cable Television Network Act in itself is not properly regulatory in nature, Your Lordship. It doesn't have any constitution of board or any regulatory matters in that way, Your Lordship.
Challenge the validity of the CTN Act.
But Your Lordship, in the instant case, the petitioners are directly affected by the removal of the said provisos of
You
the Act.
don't have any qualms about the Act per se.
Your Lordship, another point the Council would like to make is that the removal of the said provisos had a sense of guidelines for those products with genuine guidelines, Your Lordship. In the case of in the provisos, it mentioned that there needs to be a pre-certification, and there also needs to be a sale turnover. All the records have to be submitted to the chartered accountant, and also about the pre-certification. Your Lordship, the whole Act says that implies that once the advertisement is aired into the television, and if it is found offensive by any of the people, any of the citizen, only then it can be complaint can be raised and it can be referred to the ASCII code for resolvence, Your Lordship. But the pre-certification concept is very important. It is better to have something not to be put out or to be asked to change it before actually going into the media or getting affected by it. So the provisos had a sense of regulation which is now been taken away in this case, Your Lordship.
See, apparently the regulations didn't work. Apparently the regulations didn't work. That is why it was removed.
Your Lordship, the regulations...
It didn't have the desired effect. That's what the report says, and that's why it was removed.
Your Lordship, the Council would like to make a point that in the year 2000, the Rule 7, which was no direct or indirect advertisements of tobacco, were brought into picture. There were no provisos up till that. In 2009, they brought this these provisos in order to regulate the surrogate advertisements, Your Lordship.
But that is not, it is proved actually against the interest of the citizens.
Your Lordship,
It has resulted in deterioration of the health of the citizens.
Your
That
Lordship,
is the finding of the report as well as your petition, which is the basis.
Your Lordship, in the year from 2000 to 2009, it's a very long time, and the government thought that to curb the surrogate advertisement, we need some certain provisos.
Madam, on the tobacco products that you manufacture,
Yes, Your Lordship.
there is a statutory warning.
Yes, Your Lordship, that the products are meant to be injurious to health.
Tobacco
Injurious to health.
or liquor, there is a statutory warning that it is injurious to health.
Yes, Your Lordship.
Correct?
Yes, Your Lordship.
Now, that is not found to be offensive by you. That is not found to be violative of any fundamental right to do business.
Your Lordship, here the matter is about those advertisements which are not showing any sort of reference to alcohol, tobacco, or any intoxicant products, Your Lordship.
Yes.
So the case that the reference can be drawn to, like the products, the advertisement of those products couldn't be made, Your Lordship, because we are not talking about.
Can you not manufacture it as, say for example, Kingfisher water? Can you not manufacture or advertise it as Kingfisher water instead of only showing the emblem Kingfisher? Have to mention it as Kingfisher water, Kingfisher salt.
Your Lordship, as my co-counsel stated, that it is about the goodwill of the company. The company in itself has a brand established, Your Lordship. And when we for example, if you take a Kingfisher waters, there might be a lot of chances that it can become a counterfeit goods, Your Lordship. And it will have its own consequences to the petitioners in a different scenario, Your Lordship.
Now the idea is the product is not advertised. It is a name which is advertised. The product is not advertised. It is a name which is advertised. So that is the reason for this difficulty faced with the government.
Your Lordship, the said provisos were included so that the storyline, the visuals, the audio, and all the things were made sure that it is not giving out a reference to the audience that what we are selling is alcohol or anything of that sort, Your Lordship. The provisos intended to regulate it. By removing it, there is no means that the audience will get the reference of this, Your Lordship. It is better to have a regulation than a complete prohibition, Your Lordship. That is what counsel is trying to make the point, Your Lordship. Your Lordship, while interpreting a proviso, care must be taken that it is used to remove special cases from the general enactment and provide for them separately. In the instant case, the proviso shows that it was included where the legislature wanted to restrict the advertisements which were directly or indirectly promoted the advertisement of alcohol, Your Lordship. It is submitted that where a provision is doubtful, a provision in itself is doubtful, a proviso may be used to give it as the guidelines. Now, by making a general rule that no direct or indirect advertisements of such so and so products, it gives us a very vague reference that what can be included, what we as a manufacturer owning a tobacco or a certain company can put out. It doesn't give out any understanding and clarity, Your Lordship. The counsel for the petitioners is here before Your Lordships that to give out certain provisos, bring back the certain provisos, or provide clarity on this aspect, Your Lordship.
Can you kindly, in brief, explain as to what are the parameters of brand extension?
In the said proviso, Your Lordship. Your Lordship, there were two provisos. In the first provisos, they talked about the story, the audio, the visuals, and the content, basically the content aspect of the advertisement, Your Lordship. And in the second provisos, it had two folds. One was that the sale turnover of those brand extension products should be submitted.
No, my question is, what is brand extension? What are its parameters? You manufacture liquor, tobacco products. simultaneously you manufacture some other brand, some other commodity, and you promote the sales of the liquor and tobacco in the guise of the advertisements on the incidental product, which are too minor or negligible compared to your turnover, and you make use of the concept called brand extension, advertisement of these products to promote your main product, the original product.
Your
That's the
Lordship,
liquor and tobacco.
Your Lordship, the parameters of genuine brand exchange is that we might be we might be a manufacturer of a tobacco, alcohol, any company of that sort. But if we are producing another product in our own company by giving the same logo, symbol, or giving out the same brand in that sense, and then producing a different product, that would be amounting to a brand extension. Your Lordship, if Council would like to give an example of ITC, Indian Tobacco Company Limited, it is a very famous company, but it also has a lot of products. For example, a very popular student-friendly product is Classmate Books, which is now...
So those books are not given the same brand name as the prohibited articles.
Yes.
But Your Lordship,
Isn't
the ITC has...
That is the parent company. So there's no difficulty if the company involves in business in various fields. The difficulty arises when you use the same brand name for a prohibited product as also for a normal product.
But Your Lordship, ITC in itself is a logo and it is a well-established brand. That is mentioned in every Classmate Books as well. Now,
so when you advertise, you don't advertise ITC, you advertise the brand name. See, always what is advertised is the brand name.
Yes, Your
not
Lordship.
the company name.
Yes, Your Lordship. That's what we are asking. We are advertising the brand name or any other different product, Your Lordship. Now, the contention of the government is that the person can get the inferences of the original product that the company is famous to sell, Your Lordship. Now,
see, the prohibition is not for the company to involve itself in various fields of activity or manufacturing activity. The prohibition is the manner of advertising. Advertising is the brand. That's all. So the whole understanding is by advertising a similarly named product and using the analogy of brand extension, you are actually promoted a prohibited. That's all.
but Your Lordship, these are the genuine brand extensions.
All right.
And in the provisos, they gave up opportunity for these genuine brand extensions, Your Lordship. Your Lordship, the Council would like to point out the expert committee report, Your Lordship. The said expert committee report was given out after the pandemic situation happened, Your Lordship. And in the report, they clearly said that the surrogate advertisements are being influenced by a lot of adolescents, and the intake of it is a lot. And they asked to remove the two provisos, Your Lordship. But the Council would like to ask, put up a question that when social media is a new emerging technology and it is more open to getting violated, and the interests of the adolescents are more keen towards that, why to particularly limit yourself to cable television networks, Your Lordship? The said committee report didn't focus on the aspects that are beyond cable television network aspect, Your Lordship, and it is very important to know. And because pandemic was a situation where the age of technology grew up a lot, Your Lordship. And further, they had not in the fact sheet there is no data given regarding how the advertisements have been influenced to the general public, Your Lordship, especially to the adolescents. And there is no data given on how much consumption.
But your memorials itself say that the basis of your petition is a report. A report of this, what is this?
130 lakhs.
That was the number of deaths that happened. It is not a report, Your Lordship. It is just a...
No, it's a report by an NGO which says addiction-free Indies. That is the basis of your petition.
Yes, Your Lordship.
Correct.
Yes, Your Lordship.
That is a fact. But if we take that at its face value, then it gives an index that there's a need to delete these two provisos, because surrogate advertisement has really not worked.
Your Lordship, the Council is just asking that instead of completely prohibiting said provisos, they could make it more regulatory. They could make this whole CTN Act more regulatory in nature, Your Lordship. That is just what Council is pleading in this before this Honourable Court, Your Lordship. the council would like to move on to the prayer, Your Lordship.
Yes.
Your Lordship, as the council stated that this is a very important issue, and the petitioners, being the manufacturers and the models, they have their creativity, have their brand, have their occupation into this, Your Lordship. They have put ages, very much, whole of their lifetime into this advertisement, Your Lordship. So the
My brother put it, your right to manufacture any product is not affected. You still have a right to sell, you still have a right to manufacture, you can do whatever you want. But the Act provides for advertisement, which is statutory in nature. It is not a fundamental right. It's only a statutory right that you have. Now, if the statute provides for a right, the statute can also curb it. If the statute can, if the government has got the power to give you, it also has the power to take it back.
indeed, Your
The
Lordship.
question would be, is it based on some intelligible differentia? Is it based on some material? Is it based on some data? Data is available.
Your Lordship, the council, before making the prayer, would like to submit a certain data. Your Lordship, there was a report of National Family Health Survey which said that there is a two surveys done in the year between 2015-16 and 1920, Your Lordship. And here it can be found that the level of consumption of the alcohol is in question, Your Lordship. In the year 2015-16, it was 1.2 in women and 1.2 in women, Your Lordship. And the year 1920, there was 0.7 in this, Your Lordship. So the consumption level that is in the question, Your Lordship, that 130 lakh deaths happened. Actually, there was a decrease in the consumption level, Your Lordship.
Yes.
No, can come to your point.
Yes, Your Lordship. Your Lordship, in the lights of facts stated, arguments advanced, and the authorities cited, the petitioner humbly placed before this honorable court to please adjudge and declare the
One fundamental question. You've approached the Supreme Court under which provision?
under Article 32, Your Lordship.
Under Article 32, what can you ask the court to do?
Lordship, to consider this Amendment Act as ultra-vires.
The relief that can be sought under Article 32, whether it includes a declaration.
No, under Article 32.
It gives out the remedy, Your Lordship.
No. The Article 32, you can ask for certain writs.
Yes, Your Lordship.
What are the writs you can ask for?
In this case, we have
We'll come to this case. What are the writs you can ask for under Article 32?
we can ask for writ of mandamus, and we have approached that, Your
Then
Lordship.
what are the?
Writ of certiorari,
Then,
prohibition,
then,
co-warranto,
then.
habeas corpus, Your Lordship.
According to you, this relief falls under which writ?
Your Lordship, mandamus.
No, please don't ask.
Your Lordship,
Please answer.
it's mandamus, Your Lordship.
Is mandamus used to strike down a subordinate legislation? It's okay, you can answer in your reply.
Much obliged, Your Lordship. Your Lordship, the Council asked the Honorable Court to consider these rules as ultra-vires to the said Act and consider these amended rules as violated with the Constitution of Indus and pass any order which the Honorary Court may deem fit in the light of equity, justice, and good conscience. Much obliged, Your Lordship.
With my Lord's permission, may I proceed to retire?
Give us 5 minutes.
letters are coming in the serialic order, that's 1 and 2, or is it 2 and 1? No.
1 and 2.
Both the teams are coming up in 1 and 2 order, right?
Yes, proceed please.
Keep your flash. My lords, I appear on behalf of the respondents, that is Union of India. My lords, before I start, the issue before my lords, on one hand, the petitioners say, a consortium says their rights, fundamental rights are affected. On the other hand, it is the large public interest that is before my lords. Lords, on the strength of that, I will briefly set out the facts, my lords, which are not stated by the petitioner. Lords, our country is one of the large consumer market, and with 1.3 billion consumers, this is one of the largest market for any product. Lords, in our country, the cable television is regulated by the Cable Television Network Regulation Act 1995. But it's under section 22 of that particular act, rules have been framed. Well, in that rule,
you are handling the first 2 issues?
well, I will be addressing the first
2 issues.
Yes, well, under that section 22, rules have been framed. In that rule, rule 7 has become the subject matter before my lords. Lords, I am asking my lordships to kindly take the rule 7. Lordship may kindly see rule 7.
Yes.
Lords, this is the advertising code.
Yes.
Advertising carried in cable services shall be so designed as to conform to the laws of country and should not offend morality, decency and religious susceptibilities of subscribers. Plus, under clause sub-rule 2, no advertisement shall be permitted which, plus our matter falls within clause 8 minutes, promotes directly or indirectly production, sale or consumption of sub-rule 8, clause 8, cigarettes, tobacco products, wine, alcohol, liquor and other intoxicants. Lordship may see under that a proviso has been given, provided that a product that uses a brand name or logo, which is also used for cigarettes, tobacco products, wine, alcohol, liquor or other intoxicants, may be advertised on cable services subject to following conditions. If your lordship's permit, I will read the conditions. Deeply obliged. The storyboard or visual of advertisement must depict only the product being advertised and not prohibited products in any form or manner. The advertisement must not make any direct or indirect reference to prohibited products. The advertisement must not contain any nuances or phrases promoting prohibited products. Advertisement must not use particular colors and layout or presentations associated with prohibited products. The advertisement must not use situations typical for promotion of prohibited products when advertising the other products. Over here, the prohibited products is the cigarettes, alcohol and other intoxicants. These are totally banned from any way of advertisement, indirectly or indirectly. Under that, provided further, the advertiser shall submit an application copy of the proposed advertisement.
Don't read these. You just tell what your argument is.
Yes, I will say that. My lordship may kindly come to clause 2 under the provided further.
Yes.
All such advertisement, my lordship may note this, all such advertisement found to be genuine brand extension.
Yes.
This concept of genuine brand extension is the one that is being misused by the petitioners.
Yes.
That is the issue.
Yes.
Which stands before this honorable court. Because of this, they showed their products and they advertised for the prohibited products.
Yes.
Because of this, my lords, there was an increase in deaths. So, to analyze the situation, a scientific committee was formed by us. The committee did its due diligence. After analyzing the situation, the committee gave a recommendation to us. The committee gave one of the main recommendations saying that the proviso is not proper and the same needs to be deleted. Based on the recommendation, the government did its due diligence and the impugned amendment in deleting two provisions were done by the government. With great respects, if my lords is satisfied with this, may I move on with the issues, my lords?
Yes.
My lords may see in page number 10, 4 issues have been raised by us. One is whether the writ petition filed by the petitioner, namely Organization for Protection of Commercial Speech, is maintainable. Whether the impugned amendment violates Article 14, 19(1)(g) and Article 21 of the Constitution. Whether the impugned amendment is in consonance with the parent act, that is the Cable Television Network Regulations Act 1995. Whether the impugned amendment was passed to comply with international obligation and constitutional obligation. Whereas the first 2 issues will be dealt by me, Malaj, and the other 2 issues will be dealt by co-counsel. Malaj, in regards to the first issue, at the outset, Malaj, these writ petitions filed by the petitioner consortium is not maintainable, as the consortium is not the person agreed. If the for enforcing a fundamental right under Article 32, the agreed person must come before this honourable court. But the consortium which has come before this honourable court is not the agreed person, and per se, Malaj, they are not the citizens of the country. Malaj, they are juristic person. Malaj, the level of the consortium itself is a question whether the association can come and file a writ petition
Like
for this.
whatever legislation, subject matter to judicial review. In some way it has come.
Malaj, with great respects, Malaj.
Yes.
As your Lordship has said, this being a subject matter of question on merits, I am asking myself whether this particular association has right to come before this honourable court.
Yes.
Because the association contends on 2 grounds. They say their fundamental rights are affected. If the traders are going to be affected, let the traders come before this honourable court.
Yeah.
As your Lordship rightly pointed out, why can't they go before the High Court under Article 226? Well, it's state laws, central laws and central legislation can also be dealt by the High Court. But without going there, overreaching it, they have directly come before this honourable court. More than that, this particular consortium claims itself to be a consortium, but there is no details about who are the members of the consortium. They say we are the traders, manufacturers and models, but that doesn't mean how they are affected. To prove their locus standi, the owners would lie on them to showcase how they are aggrieved by it. But as of now, even now, the respondent has not shown how they are aggrieved by it. Whereas the respondent keeps on continuously arguing that on the issues of tobacco products, on the issues of alcohol products, they keep continuously arguing that they are not able to showcase their brand, so that there is a depreciation in the sales of their tobacco products. Well, I am humbly submitting before this honourable court.
No, their contention is that say you have deprived of their brand extension. Right of brand extension. They are not telling say you have curtailed my advertisement in liquor or tobacco. No. I have, incidentally, I have other products also. That was helping me overall, all put together. We are the manufacturers.
With great respects, the issue of brand extension which they contend is under the behind that, and the disguise of the brand extension, they are bringing once again the product which are prohibited to be advertised.
Suppose it's a manufacturer, name of the manufacturer itself is the brand name. Is there any bar?
Well, it's
The name of the, for example, Kingfisher.
Yes,
Kingfisher itself is a company. Correct? Kingfisher itself is a company.
well, there will be a
And also a brand name.
yes, please. Yes,
Suppose if Kingfisher is a company, it also manufactures liquor and tobacco. Is it forbidden from manufacturing any other product?
well, it's
No. Manufacturing, there is no prohibition.
not.
If there is no prohibition for manufacture, can there be any prohibition to advertise
But
Kingfisher as a product?
Plus, all these detailings, Manoj. First of all, the logo and brand name are both there in the provision.
Please come to proviso number 2.
Yes, please.
Come to the second proviso.
Well, it's provided further that. Provided further that the advertisers shall submit an application with a copy of proposed advertisement along with certificate by registered chartered accountant that the product carrying the same name as cigarettes, tobacco products, wine, alcohol, liquor or other intoxicants is distributed in reasonable quantity and is available in substantial number of outlets where other products of the same category are available, and the proposed expenditure on such advertising thereon shall not be disproportionate to actual sales turnover of the
You
product.
are reading proviso number 1. I asked you to read
Yes,
proviso number 2.
so I deeply apologize for it. All such advertisement found to be genuine brand extension while Ministry of Information and Broadcasting shall be previewed and certified by Central Board of Film Certification as suitable for unrestricted public exhibition and are in accordance with prior provisions contained in subclause 1 to 5 to first provision prior to the telecast or transmission or retransmission.
Now suppose if you have retained the power of regulation to assess whether this is surrogate advertisement or not, why can't you permit? Why can't you regulate?
Well, it's with great respect, Manoj. The issue of regulating was there, but Manoj, under this pretext of genuine brand extension, it has crept the promotion for these prohibited products.
It's not working properly then.
Well, it's with great respect, Manoj. I wouldn't say it is not working properly, but it was not as effective in controlling these things.
You change your system.
Well, it's,
you have to change your system, not change the law itself.
You retained yourself the power to determine which is a genuine brand extension. Now how can you fault them?
well, it's with great respects. The power to analyze it, the ASCI has done it, Manoj. There was a Central Board Film Certification to deal with these issues. But as a matter of fact, what happened is, under the pretext of genuine brand extension, once again, these particular prohibited products from advertisement are getting through the minds of the general public. Well, it's to solve that particular
So only after you clear it, it will go for advertisement.
Yes, Manoj.
Only after your
Yes, ma'am.
CBFC clears it, it goes for advertising.
Yes,
So
Manoj.
you have to check it. You have to check it before it is advertised.
Yes, Manoj.
So why can't you increase that level of checking?
Well, it's the increasing the level of checking was not effective. Well, it's already this level of
So
checking
the
that was
problem is not with the law, the problem is with the implementation of the law and the implementation in your hands.
Well, it's with great respects. The implementation of the law over here was done, Manoj, was done. But by some or the other
No,
means,
it appears not,
Well, it's-
because the report of the committee says otherwise,
well, it's,
isn't it?
I would bring to your Lordship's notice, the report of committee was taken into
So
consideration.
then, at best, it could be said to be a knee-jerk reaction after the report of the committee.
Well, it's,
Delete the.
well, it's deleting the proviso was done in a greater public interest. Well, it's by way of these particular regulation, that is this proviso, even though all these things were regulated, it was not as much as effective. Well, it was implemented. It was implemented. The committee
I'll
report.
come
well,
to
it's-
you, I'll come
yes,
to you. Now, you don't sell liquor, tobacco to children below 18 years, correct?
Yes,
That's the regulation.
yes,
How do you monitor that? How have you been monitoring that?
well, it's the issue of adolescents using tobacco products or liquor products is on the other side of the coin. Well, this is
No,
one
not
step.
on that.
Yes,
The law says that tobacco and liquor, alcohol products should not be sold to people who are less than 18 years old,
yes,
correct?
yes.
How are you regulating that?
Well, in regards to regulating that, we make sure that in all the installments where these products are going to be sold, it will not be given to those other young people or adolescents.
And do you think that has met the, what you call requirement?
Well, that has met the requirement to some extent. My lords, the Vatsalya committee report, it says adolescents are influenced by their role models, is in a different aspect, my lords, which I will come to the later part of my argument. But as of now, what I am trying to say before this honourable court is, well, yes, we tried regulating it.
Please put more checks in place.
Well,
Please put more checks in place to see that these surrogate advertisements are not used to sell products of liquor or alcohol. That we should do.
Well,
You can't totally, what you call, close off advertisement of these products.
well,
After all, the sale of these products is not banned. It's not prohibited.
it's true, Mitch.
So when the sale of the products are not prohibited, how can you prohibit the advertisement
Well, as your lordship rightly pointed out, they say,
of subsidiary products?
well, as your lordship rightly pointed out, the issue of brand extension over here, which they say, I'm going to sell these products. Well, if the logo or the brand name of that particular product is able to be well connected with the prohibited products, it is beyond the limit.
The company wants to encash the brand building.
Well,
It wants to encash the brand building and push other products.
I would say, the company which does these brand extensions keeps one of the part as these brand extensions, that is selling the other products. but their main motive and selling the other main motive would be behind the prohibited products. So it's under the guise of this banned extension, they are once again bringing the prohibited products. But its government over here is trying to do its best to safeguard the interest of general public matters. That is why, even though there was regulations, even though there was checks and balances in regards to the chartered accountant rules or in regards to the CBFC, ASCI, we found it to be not as effective. That is the reason why this thing was totally taken down. But the government has done its due diligence.
Suppose if it's a genuine what you call brand extensions.
Yes.
If it's a genuine brand extensions, how are you going to deal with it?
If
it's a genuine brand extension.
If it's going to be a genuine brand extension, there is a brand extension guidelines for this.
Yes.
They can go under it. Well, it's over here. The agreed parties are people who are not able to promote their prohibited products. Well, it's ultimately the aim of the government is to reduce the usage of prohibited products. Ultimately, that is the aim. Well, if I am there, I would suggest please change the logo for the prohibited products.
No,
Because
is there any prohibition? Is there any bar under law to use the same brand name and logo for a non-alcoholic or non-tobacco product?
With great respects. As far as the law is concerned, my lords, there is no any direct legislation to prohibit it.
Yeah. So it is freedom of trade. I use one particular logo for my tobacco product and a liquor product. I use the same brand name and logo for non-alcoholic product also. I want to advertise my non-alcoholic product, which incidentally carries the same brand name. Same brand name. If you feel or if you think that, say, me promoting my non-alcoholic product is indirectly boosting my sales or promoting my liquor product or the tobacco product, then you have got the check and balance under provisos. Implement them strictly as my lordship brother said. It doesn't mean that, say, you can take away or curtail their fundamental freedom to carry on that business or trade name merely because the same person or the same company produces the other byproducts or the other products which are non-alcoholic and non-tobacco.
Well, it's with great respect. As your lordship said, we are not curtailing their right to produce any product. We don't say, don't produce this product. That would be the infringement under Article 91G, but not advertising. Advertising is not a fundamental right for them.
Is it not a freedom of their speech and expression to advertise their product which is non-tobacco, non-alcoholic?
When it comes as non-tobacco or non-alcoholic, it would be protected under commercial speech. But over here, in this particular facts of the case, it comes under the disguise. These prohibited products.
You are canvassing throughout that it is coming under disguise. How? Unless there is a law, a statute distinguishing the parameters of a brand extension, and when an advertisement, say, turns out to be boosting a banned product or prohibited advertisement into putting it into force, say, I sell Kingfisher water.
Yes.
I give a lot of advertisement to Kingfisher water. I have several plants of that particular brand. Thousands of people are employed. Incidentally, the same bird, Kingfisher, what is there in the logo, is also there in my alcoholic product also, because that is my brand name, that is my logo, that is my company name also. How can you curtail my fundamental right to advertisement of my non-alcoholic product?
I understand the question. The advertisement of non-alcoholic products is not the issue. But the brand extension which they claim for selling these products, I would suggest, please retain the brand of that particular Kingfisher logo for your non-alcoholic products or tobacco products. But please change it when it comes to tobacco products. But on the other hand, I would say,
No, you don't say that. You don't say that.
You haven't said
completely removed the two provisos, which ultimately places a complete ban on advertising brand extensions. It's a complete ban now, virtually.
well, it's a complete ban. is in regards with the prohibited products and the producers or manufacturers who deal with these prohibited products. Well, it's under the pretext of brand extension. They cannot, well, it's as at the outset, my lords, all these legislations are brought for the benefit of general public on a larger interest. Well, it's and these products or the brand name or logo, well, let us say ITC itself, well, it immediately gets connected with the cigarettes or tobacco products which they manufacture. The people or the general public who buy these products are able to easily understand. That's what we came to know from these reports and analysis which we did. But as a method to stop it.
Then was it not required of you to amend the intellectual property laws, particularly the trademark laws, and confining one particular brand name
with great respect
for the alcoholic product or the tobacco product only, and mentioning that a trademark used for production of liquor, alcoholic product and the tobacco shall not be used. The same trade name or trademark shall not be carried over to their other products which are non-alcoholic or non-tobacco.
The trademark, when it comes to the aspect of trademark, the trademarks or the IPR legislation does not give them the right to advertise things. Because even now we say, please don't advertise it. We are not saying them, please don't use the trademark. With great respects, we do not say them, please don't use the trademark. The only issue over here is in regards to the advertisement. Plus the aspect of utilizing the logos.
Let's just use the example of ITC.
Yes,
ITC has products right from cooking oil to toothpaste to
yes,
whole range of commodities.
yes.
So if you prohibit them from advertising, you're practically curtailing the business.
Well, it's under ITC, the brand name would change, as your lordship rightly stated in pre-law.
So that's,
Yes,
so since you use the example of ITC to a set.
yes, yes.
All right, you proceed.
The brand name would change. Well, it's even in otherwise, per se, if the brand name is going to change, or if they started under some new brands or some in other new brand names, but it won't be an issue for them. Plus, the only issue which is before this honorable court is in regards to the advertisement.
Will's lifestyle.
Plus,
The word Will's lifestyle,
that will be prohibited.
correct? How can you justify a prohibition? Will's lifestyle deals with apparel,
Yes,
correct?
yes.
So when it is advertised, it will be shown as Will's lifestyle apparel or fabric.
Well,
Now, how do you say that this is not a genuine extension?
I would say the particular, that is where the concept of surrogate advertisement comes. The particular word wills makes it easier for people to understand and relate it with the tobacco product.
No, see, the government can't be telling you in what name the product should be marketed.
Not at all.
That
Yes,
is a different, a whole mechanism, commerce deals with that. So you can't be, yes.
Exactly. That is why I said it was brought in on a larger interest.
Yes.
On a larger interest, these legislations were brought. But other lives and health of on the higher side, under Article 19(1)(g) and 19(1) Clause A, these petitioners contend their fundamental rights are affected.
Yes.
But the government is trying to harmoniously construct both the articles.
Yes.
On one side, the government is trying to protect and safeguard the lives of general public. But ultimately the aim of the government is to reduce tobacco products, is to reduce alcohol products, in order to safeguard the rights and lives of each and every citizen. On the other hand, we are not prohibiting in entirety the production of these products. But I would say, this prohibition on advertisement itself is one of the reasonable restrictions. That is the submission which I am making for this honorable court. But if my lordship is satisfied, may I move on with the issue of maintenance?
Please.
Well, the issue of maintainability over here is whether these petitioners are really upright. Well, the Honorable Supreme Court in the case of J.M. Desai, versus Roshan Kumar, has categorized three people who approached this honorable court. Well, one is person aggrieved, another is stranger, third is busybody. Well, the judgment is referred in page number 14 of response. Over the page, the three categories have been mentioned. One is person aggrieved, second is stranger, and third is busybody. Well, these petitioners claim themselves to be person aggrieved. Well, as if it is going to be person agreed, the original owners, traders, they could have approached this honorable court, but they have not done so. A consortium claiming it to be filled with traders and manufacturers have approached this honorable court, which I would say is a busybody which is doing a publicity stunt to once again promote their products. Well, this is nothing but a busybody approaching this honorable court, which is an association, asking to say my rights are affected, asking this honorable court to seek to interfere into the matter. Well, with that, I say the petitioners doesn't have the locus standi which is this requested. Plus, if your lordship is satisfied, may I move on with the second issue? Yes. Whether the impugned amendment violates Article 14, 19(1)(g) and Article 21. Well, Article 14 is not at all violated in this regard, even if it is so as taken into a concept of classification. Well, it is a case where it is classified on basis of intelligible differentiation. Well, it is done on a reasonable manner where we check these people's rights are not affected, and the other hand we will check the rights of general public at large. Well, considering both the aspects, we have brought this legislation, so it is not violative of Article 14. Well, in regards with the concept of manifest arbitrariness.
How do you overcome the concept of arbitrariness?
Well, I will come to it.
Yes.
Well, in regards to the concept of manifest arbitrariness. Well, manifest arbitrariness is a place where, when I negated them in totality, or when I am bringing some legislation or some rule in total arbitrariness, or when it is not supported by any material, or when it is subjective, or when it is done with some ulterior motive. Well, over here, the interest of public is taken at large. Well, there is no manifest arbitrariness. We have not negated these people's right in entirety. We have not stopped their trade or practices. Well, even this honorable court, under Code Distillery's case, has said it is necessary to stop and prohibit the sales of intoxicants. Well, that is the place where we all come to.
We are not dealing with intoxicants.
Well,
this is not a case of sale of intoxicants or a ban on sale of intoxicants. It's a ban on sale of extended products.
Well,
so therefore, you have to justify whether this is done on a non-discriminatory basis, number one, whether there is some object sought to be achieved, what is the basis. These are three things. What is the basis for this rule? What is the basis for deletion of this rule? And whether there is some rational object to be achieved.
If my lordship grants me 2 more minutes,
3 minutes more.
Yes, well, it's the aspect, as my lordship said, whether there is any discrimination in this. My submission is that there is no discrimination in this, because the Vatsalya committee itself has heard these people, has heard each and every stakeholders. My lordship may kindly see the facts, where it is clearly stated the stakeholders were heard. They were given their opportunity to submit their case. Well, the due diligence was done by the government before bringing the statute, before bringing the impugned amendment.
What is the basis? You already have a right to regulate. What is the basis? What is the justification for you to totally close off? What is the justification for you to close off?
For the purpose of basis, we have conducted a scientific study on basis of Vatsalya committee. On that, we have done our due diligence. Well, on all those scenarios, even the NGO report, as well as the number of deaths in relation to tobacco products are the basis. Well, we are able to reliably understand that there is certain issues in the society. And as a government, we are obligated to rectify it. And we are doing it under the pretext of removing and deleting the provision.
Was this report of Vatsalya placed before the parliament?
Well,
discussion.
Well, to answer this, the report of Vatsalya committee was taken into consideration by the government, which is the rulemaking. But this rule, under section 22, was placed before the parliament, and on basis of that, it was notified.
So therefore, to deletion of these two provisos, was this report placed before the parliament for acceptance?
Well,
because these rules are framed by the parliament.
Well, these rules are framed. Your Lordship may kindly come to section 22.
Yes. Would it be placed before the parliament?
Of the Act, Cable Television Act.
Yes.
Well, the rules were placed before the parliament. Well, Lords may kindly say section 22.
Yes.
where the central government by notification in official gazette may make rules to carry out the provision.
Yes.
My Lordship may kindly come to clause 3.
Please come to clause 3.
Yes, please. Every rule made under this Act shall be laid as soon as may be after it is made before each House of Parliament while it is in session for total period of 30 days, which may be comprised in one session or in 2 or more successive sessions. And if before expiry of the session immediately following the session or the successive sections of a state, both houses agree in making any modification in the rule, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form or be of no effect as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under that rule.
So therefore, is it required that you must have placed
Minutes?
amendment rules before the Parliament?
Yes, minutes. The amendment rules.
Whether this report of Vatsalya must have been placed before the
If your
Parliament?
Lordship gives me 30 seconds, I will complete. Well, the Vatsalya committee report was not placed.
It was not placed before the Parliament.
It was not placed. But after framing of the rules, for the purpose of notification, this rule, deleting this provision, was placed before the Parliament and the same was debated. And thereafter it was notified, which would impliedly be a way of keeping the Vatsalya committee's report. Yes, minutes. With that, I conclude. I rest my case, minutes. I am deeply obliged, minutes.
May it please your lordships, if the council addresses the bench's lordships collectively. Much obliged, your lordship. Your lordships, I will be dealing with issue 3, your lordships. If your lordships permit, I will proceed. Much obliged, your lordship. Issue 3, your lordship. Whether the impugned amendment is in consonance with the parent act, that is the Cable Television Networks Regulation Act of 1995, your lordship. I would like to make this most humble submission, your lordship, that the intention of the legislature while legislating the act was to regulate the operation of the cable network throughout the country for regulating the shows and advertisements for being telecasted in the television, your lordship. And the old proviso permitted surrogate advertisements, your lordship, for alcohol and tobacco products, which is passed under the rule making power, which is established in section 22 of the same act, your lordship, wherein the central government also has the powers to make the rules that supports the objects and the intention of the parent act, your lordship. While that being the intention, the entire proviso of the Rule 7 of the Cable Television Network Regulatory Rules of 1994 was not in consonance with the object of the parent act, your lordship. To solve the dilemma as well as the repugnant position of Rule 7 of the cable rules, the impugned amendment was passed by the Union Government, your lordship. The earlier proviso, I would like to focus on that the earlier proviso, Rule 7, is not in consonance with the object of the parent act, your lordship. The rules are not only in consonance with the parent act, your lordship, but also it is in agreement with the CODPA, your lordship. The Cigarettes and Other Tobacco Products Prohibition of Advertisement and Regulation of Trade and Commerce Production, Supply and Distribution Act of 2003, your lordship. The CODPA, by the way of section 5, prohibits advertisement of any tobacco products by way of any direct or indirect means, your lordship. The ambiguity in regards to the situation of advertisements of tobacco products as the CODPA totally prohibits, your lordship, any form of direct or indirect advertisements, your lordship. But pertinent to that, the earlier proviso, Rule 7 of the Cable Television Networks Act, permitted advertisement in an indirect form, your lordship, with certain restrictions. Therefore, there was a contradiction situation, your lordship, in both the act and the rules. And the same led to the issue of ambiguity as to which shall be followed, your lordship. In order to solve the ambiguity, in order to solve the dilemma, this amendment is brought into force, your lordship. The concept of surrogate advertisement, your
Please
lordship.
come again. What is the dilemma that was faced by the government? What was the dilemma?
Your lordship, in the rules, we are given a proviso to make surrogate advertisements, your lordship, but the intention was to complete, in the intention of CODPA was to completely ban direct or indirect way of advertisements, Your Lordship.
Yes.
Yes, Your Lordship. This is the ambiguity that is being...
So what you are trying to say is the Act wanted to prohibit completely, and the rules provided surrogate advertisement.
Yes,
So therefore,
yes.
there you say the government faced a dilemma.
Yes, Your Lordship. The concept of surrogate advertisement, Your Lordship, is where the advertisements of particular product is made by using the logo of the same brand in some other situations, that it doesn't directly intimate about the product, but immediately sends information and advertises the original product, Your Lordship. That is, for example, the logo of an alcoholic product is being used in the jersey of a sportsman, Your Lordship. Therefore, this model of surrogate advertisement was permitted by the earlier proviso, Your Lordship, and that is why we are completely removing this proviso in Rule 7, Your Lordship. The CODPA that the Parliament legislated is in such a manner that it prohibits any manner of advertising or promoting of alcoholic and tobacco products, Your Lordship. However, the cable television network's rules, as stated above, is contradictory to Section 5 of CODPA, Your Lordship.
Court? Please come in.
CODPA.
Court?
CODPA.
What is court?
Cigarette and other tobacco products.
Page 22.
The prohibition of advertisement,
Yes.
Act of 2003, Your Lordship.
Yes.
Much obliged, Your Lordship.
Please don't use this abbreviated forms.
Apologies on my side. Your Lordship.
Please don't use this CODPA and all those.
Apologies on my
Please use
side.
the full form.
First you elaborate the
First
name
you should
and
say
then
what is CODPA. First you should elaborate what is CODPA.
the
Thereafter
next
you
constitution
can-
will say COI. Please
Your
don't
Lordship-
abridge it in the first go. Once it
Your
becomes...
Lordship,
Yes.
I did
Yes.
mention the name
All
of the
right.
Act in the before.
All right.
Much obliged, Your Lordship. Your Lordship, in the case of TV Today Network Limited versus Union of India, Your Lordship, the same ambiguity between the Cigarette and other tobacco products Act of 2003 and the Cable Television Network rules came to be challenged before the Honorable High Court of Delhi, Your Lordship. It also raised the question which regards to the surrogate advertisement, Your Lordship. And in order to solve the ambiguity in here, we have brought this amendment, Your Lordship. This is also done with all legal pronouncement with the health and safety of the general public, Your Lordship. The general public's health and safety was given the utmost importance in here, Your Lordship. The rules that are framed cannot go against the intention of the Parent Act, Your Lordship. The same cannot go any other parliamentary legislation, Your Lordship. In this scenario, cigarettes and other tobacco products Act of 2003, Your Lordship. Pertinent to that, this rules was framed under Section 22 in a format of a delegated legislation, Your Lordship, where the Parliament has delegated its rule-making power to its subordinate body. The subordinate body cannot go beyond the scope and the ambit of the Parent Act, Your Lordship. The said principle has been reiterated again and again in the Honorable Apex Court of Kathena, Your Lordships. And the intention of the Parent Act was to maintain and streamline the situation of the surrogate advertisement. Therefore, this impugned amendment came to be passed in the lines of object and scope of the Parent Act, Your Lordship. If Your Lordships are satisfied, may I move to issue 4? Much obliged, Your Lordship. Issue 4 here, Your Lordship, whether the impugned amendment was passed to comply with the international obligation and constitutional obligation, Your Lordship. The impugned amendment came to be passed with the consonance with the international treaties and conventions, Your Lordship. The 14th plenary meeting urged its members of the World Health Organization to implement the measure to ensure effective protection to non-smokers as well as children and other young people in the society, Your Lordship. The under WHO framework, WHO Framework Convention for Tobacco Control, all parties to the treaty must institute a comprehensive ban or on tobacco advertisement, promotion and sponsorship within 5 years of the convention's entry, your lordship, into the force of the country. Article 13 of the WHO Framework Convention for Tobacco Control outlines this obligation and guidelines, your lordship. Evidence show that the comprehensive advertising bans leads to reduction in the number of people that start and continue to smoke, your lordship. Statistics has also illustrated that the banning of tobacco advertisement and sponsorship is one of the most cost-effective ways to reduce tobacco demand, your lordship. Article 51 of the Constitution,
The purpose of the amendment in your stated object is not to comply with our international obligation. It is saying that studies show that that's why those provisos are deleted.
Your lordship, this is also taken into consideration in order to make this amendment, your lordship.
No, that's not available in the fact situation. The fact which
Yes.
is covered on your issue number 4 is not in the statement of facts. Yes, all right, proceed.
Yes, your lordship. Under Article 51 of the Constitution, it becomes a duty upon the state to obligate and respect any international resolution, treaties and agreements, your lordship. Similarly, the Cigarette and Other Tobacco Products Act of 2003 was also one such statute that was passed on the basis of the international obligations, your lordship.
Fine.
Yes, your lordship.
So now, probably a conflict arises between an international obligation and the fundamental right of a citizen, guaranteed to him under Constitution.
Yes, your lordship.
So if a citizen contends that he has got fundamental right to carry on a particular trade or business and to promote its trade of his product, say to carry out the advertisement also, then merely because some international obligation or a treaty or a convention for which India is a signatory,
Yes, your lordship.
say imposes certain restriction or recommends its member states to impose certain restriction, can his fundamental right be abrogated or taken away, ignored? Which prevails, an international obligation under a treaty or a convention, or the constitution of the state?
Your lordship, the fundamental rights, the constitution of the state will prevail over the international obligation, your lordship.
Yes.
We are bringing this international obligation in this case in order to make, in order to submit that this is also taken into consideration, your lordship, in order to make this amendment, your lordship. By,
You are
yes,
speaking with a forked tongue. On the one hand, you allow these products to be manufactured and sold.
yes, sir.
You do not prohibit the advertisement of these products and its extension in other forms. It could be social media, it could be print media, it could be electronic media. That is not prohibited. Selectively, you prohibit the products only on the cable television network. So you are speaking with a forked tongue. The government is not dealing effectively to implement the international obligation.
Your lordship, in accordance to the committee's highlights, your lordship, they have specifically mentioned cable television because, your lordship, it is creating more impact, your lordship.
So the
Yes,
government has not applied its mind, it's just gone by what the committee has said.
No, your lordship, it has done its due diligence, your lordship. It has kept all these points in mind in order to bring this amendment, your lordship.
Yes.
If your lordships proceed, can I?
Yes.
Much obliged, your lordship. It is pertinent to note that the Article 253 of the Constitution permit the Parliament to legislate and to implement international agreement and resolutions, your lordship. It is the duty of the state to adopt the international resolutions into domestic legal system, and the laws are to be required to be legislated in the same, your lordship. The Impugned Amendment came into was passed under the guidelines of the resolution which was passed under WHO, your lordship. Your lordship, this Impugned Amendment is not based on any apprehensions, summaries or theories, your lordship. It is backed by an empirical data and survey that is conducted by the government, your lordship. The committee, after its detailed analysis, several conferences and a detailed report came and submitted before the government, and the government has passed the impugned amendment only on the basis of the said report also, Your Lordship. It is to note that the report was filled after much deliberation and due diligence, after taking into consideration the submission that are submitted by the stakeholders also, Your Lordship. The recommendation of the committee was that the surrogate advertisement are very effective, and they make the audience completely understand what they are advertising, Your Lordship. The adolescents follow their role models and adopt the brand that they endorse, Your Lordship. The committee also strongly recommended that the two provisos to the cable under Rule 7 of the Cable Television Network Regulations Act of 1995 are to be dropped forthwith with the interest of the general public, Your Lordship. Therefore, I would like to humbly submit that the impugned amendment in here is on basis of an empirical data, Your Lordship, and it is done only after due diligence, Your Lordship.
Where is the empirical data, madam, in your memorials? Have you given the empirical data?
Your Lordship, it is given in the facts, Your Lordship. Dr. Vatsalya's committee's...
After the Vatsalya's committee report,
yes, Your Lordship.
what has your, in-house committee recommended? What is the empirical data collected by you for the basis of accepting Vatsalya's report?
Your Lordship, the council is trying to say, make a submission that the Vatsalya's committee report
Itself is
is
the empirical data.
yes, Your Lordship, as it can be considered as a scientific research, Your Lordship. It is being led by Dr. Vatsalya, who is a psychologist, Your Lordship.
Yes. You look at
Who
the
is
committee.
Yes, Your
Look
Lordship.
at the committee constituted. Please have a look at the committee. Who are the members of the committee?
Your Lordship, the members of the committee is led by a psychologist, Your Lordship, and the members of the committees are experts from wide fields of marketing, economics and medicine, Your Lordship.
Yes. Why have you not involved the manufacturer of these products?
Your Lordship, they are all considered as a stakeholders, Your Lordship.
The biggest stakeholder is the manufacturer.
Yes, Your Lordship,
So
and we
he
have...
doesn't have a say in the committee.
The committee took a wide consultation from all the stakeholders, Your Lordship. After extensive conferences, detailed conferences, and a report was filed to the central government by this committee, Your Lordship.
Correct.
Therefore, we consider this committee's report as an empirical data, Your Lordship.
Yes.
Much obliged, Your Lordship. If Your Lordships are satisfied, may I move to the prayer, Your Lordship?
Yes.
Wherefore, in the lights of the facts presented, issues raised, arguments advanced, and authorities cited, it is humbly and respectfully prayed before this honorable court that it may be pleased to adjudge and declare and dismiss this writ petition filed before this court and
Madam,
other...
you ask,
Yes,
you
yes.
say adjudge, declare, what?
Declare to dismiss this...
So the question of adjudge and declare doesn't come. May be pleased to dismiss.
Yes.
There ends.
Much obliged.
Adjudge and declare would come when you want the court to declare something. Correct?
We want the court to
To dismiss.
dismiss this writ petition.
You are opposing the petition.
Yes, Your Lordship.
Whatever their prayer may be, you want dismissal of the petition.
That's all.
Yes,
That is all.
It appears to be copy paste from. From all right.
And pass any other order, direction or relief that may deem fit in the interest of justice, equity and good conscience. And for this act of kindness, the respondents, as in duty bound, shall humbly pray.
Yes. One very fundamental question.
Yes,
What, according to you, is the difference between Article 226 and 32?
Your Lordship, under Article 226, we can approach the High Court, Your Lordship, and under Article 32, we can approach the Supreme Court, Your Lordship.
Apart from that, anything else?
If Your Lordship's permit me, may I take a 30 seconds to refer, Your Lordship?
No, without referring, you try and answer, then you can come back and tell it. So apart from this basic distinction, you don't think there's any other difference between 15?
Your Lordship, it
226.
will be dealt in the rebuttals, Your
All
Lordship, by
right.
Your court.
All right.
Much obliged, Your Lordship.
Yes.
The council seeks permission for the
I think two things, don't just put out your point, don't argue, and in the response also counter the locus standi ground.
questioning about why we came as a consortium, that is our locus standi. Your Lordship, it's an association framed by individuals, and here the manufacturers are members of the association and they do have the fundamental rights. To claim their fundamental rights, they came as a consortium and filed a writ petition in the Supreme Court, Your Lordship. And the council mentioned that they relied on the World Health Organization Framework Convention for Tobacco Control, but the WHO Framework Convention tells to institute a comprehensive ban on tobacco advertisement, but doesn't in any way tell to ban the brand extensions itself. The counsel for the respondent also stated about how people are getting influenced by the logos in the jerseys, but in the present case, the ban is only on the cable TV advertisements and not on the jerseys.
No, but what you didn't answer about the locus standi.
Your Lordship, the locus standi, the question was about why we came as a consortium and why not as individuals.
No, but what is the right that that this organization has? Does it have a statutory right? Does it have a fundamental right to come up to approach the court directly under 32?
Your Lordship, right to form association is given under 19(1)(c).
Does it per se have any right? Whether the organization or the consortium, does it per se have any statutory or fundamental right to come to the court and say that my fundamental rights is violated?
Yes, Your Lordship, since the association has members who are citizens and
The members are not parties to the litigation.
the consortium is, and the consortium is of the citizens, Your Lordship, and the members are the manufacturers and the models.
It could be, but the consortium doesn't manufacture.
See, is it your contention that violative of 19 and 21, correct?
Article 19 and 21. Article 14 also.
Also,
14, 19.
okay. Now, 14, 19, 21 are available to, there are certain individual rights which cannot be claimed by entities. An Article 21 right cannot be claimed by an entity, correct? And Article 21 right can only be claimed by an individual.
Yes, Your Lordship, but
So in the absence of an individual being a party, then violation of 21 cannot be alleged.
violation of 21. Pardon, Your Lordship, the council actually...
In the absence of an individual being a party, violation of Article 21 cannot be
Look
alleged.
at Article 14. Have a look at Article 14. What is it? What does the opening words of Article 14 begin with?
Equality before law.
Yes.
The state shall not deny to any person,
Person.
any person.
Yes.
Yes,
So
Your
person includes
person.
a natural person and a juristic person. Correct?
Yes.
Assuming that you are a juristic person, is your right infringed? Is your right infringed is a question put out to you. Then you please come to Article 19. How does it begin?
All citizens shall have the right.
Are you a citizen?
The members are the citizens.
Is the petitioner a citizen?
Petition is a consortium.
Yes, Your Lordship.
So petitioner cannot be a citizen. Please go to Article 5. Article 5 deals with who is a citizen. Yes. So therefore, what right you have under Article 19?
Lordship, here what the petitioners were focusing is on the stakeholders' right, Your Lordship.
Correct. Then you cannot complain of violation of a fundamental right as a citizen.
But even if the,
Complain of violation of a fundamental right, you should be a citizen. You are not a citizen. That is a distinction. Now you please come to Article 21.
protection of life and personal
Yes,
liberty.
please read the opening words.
No person shall be deprived.
Person. It talks of person, not a citizen. So 19 is meant only for citizens. Article 14 and Article 21 are meant for all persons. Persons include
Juristic person.
a juristic person and a natural person. Correct? In your case, if you think that you are a juristic person, what is your right to come to the court is a question. You must have been affected by this deletion. If you are not affected, you be remedial. If you have a right, you have a remedy. If you don't have a right, you will not have a remedy. So therefore, how do you justify? Is the question put out by my lords.
It's an association of persons, a consortium. So persons do have the right under 21, Article 14, Article 19. So that is the reason why we filed a consortium and we are filing before the Supreme Court for the violation of these rights.
Yes.
With my lord's permission, I move place minutes. Lords, I am making only the rebuttal submissions to the rebuttals made by the petitioner's counsel. Lords, in regards with locus standi, I am not going to address here after Mullers, as your lordships just pointed out. Lords, in the next aspect, the WHO regulations, which has been stated by the petitioner. Lords, it is one part of argument which we are placing before this honorable court. Lords, even though 43rd WHO regulation was to prohibit the whole sale of tobacco products, that was not the intention because it would go against Article 19(1)(g). Lords, that is why we are putting reasonable restrictions one by one. Lords, that is the answer for that. Lords, in regards with the other issues which have been totally raised by them, Lords, being a juristic person, their rights being set as affected is not the criteria for them to approach this honorable court. Lords, under Article 32, being a fundamental right, it can only be sought by a person who is a citizen of this country. His fundamental right is violated. The person under Article 32 should be a person who is citizen of this country. With this, I rest my case. Deeply obliged. Yes, ma'am.
We have approached the highest court in the country.
Yes, ma'am.
Now, the petitioner has brought out to the notice of the court about a statutory violation of the statutory right which has pan-India consequences. So therefore, why shouldn't the Supreme Court, in exercise of its power under Article 141, exercise and pass appropriate orders?
With great respects. Article 141 and 142 is wide. I am not touching upon it. I leave it before this honorable court after making my submissions to be considered. Plus, my submissions are made, the impugned amendment are made in regards to the general interest of larger public. With that, I rest my case. Deeply obliged.
I think some reply or co-counsel want to give in rebuttal. We assume all right.
Yes,
Doesn't
ma'am.
matter. Doesn't matter.
It should be made in pen or pencil. The pen? Anything is fine? Yeah, that's okay.
already marked in pencil, then it's fine.
Let me just write it off.
Yes. ಅಲ್ಲ ಇದು ಅಲ್ಲ ಆಗಿದೆ
Two. Aida.
ಸರ್ ಇದು ಎಕ್ಸ್ಟ್ರಾ ಎಲ್ಲಿಟ್ಟಿರಲಿ ಇದಿಲ್ಲಿ ಇಟ್ಕೊಂಡಿರಲ್ಲ
ಹಾಂ ಇಟ್ಕೊಂಡಿರಿ
One, two, hello.
pitch dark at the back. All in the hand signal impossible hand signal.
Hello, 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 check, mic testing 1, 2, 3. Hello, hello.
As the dignitaries have arrived, I request all present here to rise from their seats and give a big round of applause to welcome the guests. Extremely sorry.
You're making
Kindly rise. Champions aren't made in gyms. Champions are made from something they have deep inside them. A desire, a dream, a vision. They have to have the skill and the will. But the will must be stronger than the skill. Muhammad Ali. Good evening to one and all present here. With great joy, I, Ms. Maitra, Assistant Professor of Law, on behalf of Rashtriya Shikshana Samiti Trust and RV Institute of Legal Studies, welcome all the dignitaries, participants, teaching and administrative staff, invitees, and my beloved students to the first All India Moot Court Competition 2023's valedictory ceremony. Energies to be manifested in one's life. Time spent in prayer refreshes, renews, and strengthens. I now call upon Ms. Pragati and Ms. Maheshwari from first semester BBA to invoke the blessings of Almighty.
गणनायकाय गणदैवताय गणाध्यक्षाय धीमहि गुणशरीराय गुणमण्डिताय गुणेशानाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि गानचतुराय गानप्राणाय गानान्तरात्मने गानोत्सुकाय गानमत्ताय गानोत्सुकमनसे गुरुपूजिताय गुरुदैवताय गुरुकुलस्थायिने गुरुविक्रमाय गुह्यप्रवराय गुरवे गुणगुरवे गुरुदैत्यकलक्षेत्रे गुरुधर्मसदाराध्याय गुरुपुत्रपरित्रात्रे गुरुपाखण्डखण्डकाय गीतसाराय गीततत्त्वाय गीतगोत्राय धीमहि गूढगुल्फाय गन्धमत्ताय गोजयप्रदाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि ग्रन्थगीताय ग्रन्थगेयाय ग्रन्थान्तरात्मने गीतलीनाय गीताश्रयाय गीतवाद्यपठवे ध्येयचरिताय गायगवराय गन्धर्वप्रियकृपे गायकादीनविग्रहाय गङ्गाजलप्रणयवते गौरीस्तनन्दनाय गौरीहृदयनन्दनाय गौरभानुसुताय गौरीगणेश्वराय गौरीप्रमयाय गौरीप्रवणाय गौरभावाय धीमहि गोसहस्राय गोवर्धनाय गोपगोपाय धीमहि गुणातीताय गुणाधीशाय गुणप्रविष्टाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि एकदन्ताय वक्रतुण्डाय गौरीतनयाय धीमहि गजेशानाय बालचन्द्राय श्रीगणेशाय धीमहि
Thank you, Pragati and Maheshwari. That was divine. When you are around enormously successful people, you realize that their success isn't an accident. It's about hard work. We are really fortunate to have such eminent guests among us on this great day. Now I request our principal, Professor Dr. Anjana Reddy KR Sir, to welcome the guests and the gathering.
Good evening to one and all. It's my privilege and honor to welcome you for the valedictory program of the first All India Moot Court Competition 2023, organized by RV Institute of Legal Studies, Bangalore. Gratitude is a demeanor of nobility. I extend my heartfelt welcome to the chief guest of today's event, Honorable Dr. Justice H.B. Prabhakar Shastri, Judge, High Court of Karnataka. His Lordship is an epitome of integrity. Privileged are those who are able to learn the conducts of the profession from His Lordship. And Lordship is a great academician also. I kindly request Mr. Tejas, Assistant Professor RVLS, to hand over a bouquet to a token of respect. I extend a warm welcome to Honorable Justice R. Natraj, Judge, High Court of Karnataka, the guest of honors of today's event. His Lordship is paragon of virtue. I must state very thankfully that when I went to invite His Lordship, he instantly agreed to grace the event. Lordship respect towards academicians and educational institutions is highly applaudable. I kindly request Ms. Vaishnavi, Assistant Professor, RV Institute of Legal Studies, to hand over the bouquet and token of respect. Thank you. Madam Banima. I also extended my greetings to Honorable Justice C.M. Punacha, Judge, High Court of Karnataka, the guest of honors for today's event. His Lordship as an epicenter of inspiration of all the young minds here, as he is a young achiever, to take on the bench despite having a very fertile practice, is sheer act of sacrifice, something which all the youngsters here must imbibe. I kindly request Mr. Rao, Admin Officer, RVLS, to hand over the bouquet as token of respect. I would like to welcome today's President of the program, CA Dr. A.S. Vishnu Bharat, Chairman, Governing Council, RV Institute of Legal Studies, and Trustee RSST, who is always extending his support to organize all the programs. I welcome you, sir, on behalf of RVLS, and I request Mr. Bharat, Assistant Professor, RVLS, to hand over the book. I also extend my warm regards, greetings to Assistant Professor Bhavana C, Coordinator of RVLS Moot Court Academy. From dawn to dusk, from quilts to moonlight, she has served insistently in this event. Her efforts are seen standing tall and proud today. I kindly request my Chaitra to hand over the book as token of respect. I welcome the other coordinators of RVLS Moot Court Academy, who has been a stellar support for bringing out this flagship event. Faculty members, administrative staff, and my dear student coordinators and beloved volunteers, without whom this day would not have been a success event. I also my heartfelt welcome to the students and participants who have come across the country. I wish the very best to all the participants in all your future endeavors. I also welcome the press and media. Thank you once again, one and all.
Thank you, sir. I take this opportunity to extend a warm welcome to our beloved principal, Professor Dr. Anjana Reddy KR, who has contributed immensely in building this institute. Welcome you, sir. I request Mr. Pratik Bhargava to hand over the book to Principal Sir as a token of love and welcome, sir. Thank you, sir. They say, believe you can, and you are halfway there. With the belief of building a premier legal institute, Rashtriya Shikshana Samiti Trust built RV Institute of Legal Studies in the year 2018. Reputed ranking organizations such as Education Today's Top Higher Education Award, Outlook India's iCare rankings, and many more have ranked our institute's accomplishments, achieved within a span of 4 years. It's no exaggeration to say that our institute has become the new landmark of world-class legal education. I feel overwhelmed while announcing it before you that just yesterday, there has been a news we have received regarding our college ranking. We have been ascending rise in the rank awarded by the New Education Post to our institute from 37th place in the year 2021, 34th place in the year 2022, to 22nd place in IIRF rankings 2023. Secured amongst top 50 private law colleges in India, and also Outlook has given us 18th place. Also stands within the list of achievements of our institute. Swagle, Assistant Professor of Law, over to you, ma'am.
Are not those which come while we are sleeping, but dreams are those when you don't sleep before fulfilling them. I unquote. RV Institute of Legal Studies Moot Court Academy was constituted with the goal to afford the young and aspiring lawyers an opportunity to decipher substantive issues of law. Patil, Professor of Law, Karnataka State Law University, Hubballi, for supporting us with the first step towards accomplishing the dream by drafting the Moot proposition, which was based on the facets of constitutional and administrative law. The Moot proposition was officially released and the participation invite was sent to all the legal institutions and law universities across India on 9 December 2022. The brochure was also publicized on our institute's website, social media handles, and on Lawtopers, Law Bhumi and other web pages as well. The provisional registrations were completed on 31st December 2022 and the final registrations were completed on 9th January 2023. We are thankful for having received an overwhelming response from more than 45 institutes from across the nations. As a rule of early bird registration, a total of 24 teams were being selected to participate. The competition was inaugurated on 24th February 2023 at 5:30 p.m. by a renowned jurist and a legal visionary, Honorable Mr. Justice S. Rajendra Babu, former Chief Justice of India and former Chairperson, National Human Rights Commission, New Delhi, as the Chief Guest of the day. It was a privilege to have as the guest of honor Dr. Nigam Mukkehalli, Registrar, National Law School of India, University, Bengaluru. Besides, we had Dr. M.P. Shyam, President, Rashtriya Shikshana Samiti Trust, Bengaluru, presiding over the occasion, and Professor Dr. Anjana Reddy K.R., Principal, RV Institute of Legal Studies, graced the occasion. The draw of lots, exchange of memorials for the preliminary rounds 1 and 2, and the researcher test were simultaneously conducted on the same day. The test consisted of 50 objective type questions relating to the Moot proposition, law applicable, and the allied laws. On 25th February 2023, the preliminary rounds 1 and 2 were held concurrently in 12 court halls, wherein each team were provided with an opportunity to appear on behalf of petitioners as well as the respondents. The quarter-final rounds were held in the second half of the day, and top 8 highest scoring teams in PR 1 and 2 qualified to the quarter-final rounds. Both the rounds were adjudged by 32 prominent advocates and partners in leading law firms as well as the academicians. The top 4 scoring teams won the quarterfinals were judged on a knockout system for the semi-final rounds, which were held this morning. The bench judging this round comprised of district judges and other legal luminaries. The much awaited final round took place in the afternoon today. It was an honor to have a bench comprising of 3 currently serving judges of the High Court of Karnataka, Bengaluru, judging the final round. We are deeply thankful for the immense support
competition, I take this opportunity to express our sincere gratitude to the judges on behalf of Rashtriya Shikshana Samiti Trust and RV Institute of Legal Studies. Thank you so much, sirs. It was an honor to present before you the proceedings of the first All India Moot Court Competition 2023. Thank you.
Thank you, ma'am. Dr. H.P. Prabhakar Shastri, Judge High Court of Karnataka, Bengaluru, as Chief Guest of the day. I request Mr. Vishal V. Naregal, student of 7th semester BBA LLB, to introduce the Chief Guest.
Good evening to one and all present here. It is indeed my honor to introduce the Chief Guest of today's program, Dr. Justice H.P. Prabhakar Shastri. Dr. Justice H.P. Prabhakar Shastri completed his BSc degree at DRM Science College and LLB degree at RL Law College, both from Mysore University at Davangere. He did his MA degree in Philosophy and Master of Law degree in International Law from University Law College, Bengaluru, and started his practice at Bengaluru under the seniorship of Sri A.N. Jairam, a designated senior advocate who later became Additional Solicitor General of India and Advocate General of State of Karnataka. After a few years, he established his independent office at Seshadripura, Bengaluru. Dr. Justice H.P. Prabhakar Shastri has practiced in High Court of Karnataka, various trial courts, various tribunals and authorities in Karnataka, in different facets of law, including writ, civil and criminal matters. For a short time, he has also gained experience of legal profession in the United States of America and appeared in the federal courts of San Francisco and Court of Appeal of California through Murray B. Peterson, a law firm at Oakland, California, USA. Dr. Justice H.P. Prabhakar Shastri has also taught law as a guest faculty in the University Law College for 10 years, Sri Jagadguru Renukacharya Law College and Seshadripuram Law College for many years. He has also taught law for a trimester in National Law School of India University, Bengaluru, immediate prior to his appointment as a district judge. After his appointment as a district judge on 27 May 2002, he has served in several districts of the state of Karnataka as a district judge and later as the principal district judge of a few districts. He is the first recipient of the state award for. He is the first district judge from the state of Karnataka to serve as registrar in the registry of the Honorable Supreme Court of India in the year 2011. He was awarded with the degree of Doctor in Philosophy by National Law School of India University, Bengaluru, a most reputed university in the field of law, in its convocation held on 31st August 2014. Dr. Justice H.P. Prabhakar Shastri was elevated as an additional judge of High Court of Karnataka and sworn in on 21st February 2017 and later became permanent judge and has been serving as a judge of High Court of Karnataka. He is one among the senior sitting judges of the High Court of Karnataka as on date. I once again welcome His Lordship on behalf of our Rashtriya Shikshana Samiti Trust and RV Institute of Legal Studies. Thank you.
Thank you, Vishal. Now I request Honorable Dr. Justice H.P. Prabhakar Shastri to address the gathering. Over to you, sir.
Respected guests of this today's evening function, my Lord, Honorable Justice R. Nataraj, my Lord, Honorable Justice C.M. Punacha, the brother judges, Dr. Vishnu Bharat, Chairman of the Trust, Professor Dr. Anjana Reddy, Principal of the RV Institute of Legal Studies, teaching and non-teaching faculty members of the institute, participants to the first All India level Moot Court competition, my beloved student friends, media persons. When I was doing my law in the 1980s, it was from a Mofusal college at a place called Davangere within the Mysore University. Then there was no concept of law university for state as such. This concept of moot court was not much known to the students, for that matter even to myself. What is the prescribed syllabus? What is the minimum marks we are expected to secure to get eligibility for the next academic year? Was only our knowledge, and that's what we knew at that time. In fact, this concept of moot court, mock parliament, all these things students are very fortunate that during their LLB curriculum itself, they get exposed to several of these activities, including moot court, which is very much needed for a law student to become a good advocate. A syllabi, the subjects, if you study, understand, analyze or mug up, okay, that is sufficient to say. Which a person has, every day would be an examination for him in every matter. He may be a rank holder or a gold medalist in academics, but he is not much exposed to or is not aware about the court etiquettes, the advocacy skills, presentation of the case, analyzing the case file. Then he may find some, in that regard this moot court will help a lot. Today's moot court was one of a judge in finals. All the three of us had gone through the memorials submitted by both sides. I find the memorials prepared and presented by both sides was very good. We were feeling, amidst of the argument, we were feeling that, say, we are actually sitting in a court hearing the arguments of some experienced advocate who has put not less than accurate arguments were addressed before us. So, four eminent advocates and research scholars who assisted the presenters of the case, we could be able to hear today. So, our job became a bit difficult and tough because the competition was so close and neck to neck. Ultimately, we have to declare one team. It's not that, say, we spent our Sunday times and our other work to come over here, but I think personally, maybe the same would be the opinion of my brother lordships also, that we were fortunate that we could hear a good argument from both the sides today in moot court competition. What ultimately we is that first marshal the fact, study the facts. Many times a simple or bare reading would not give you exactly what the crux of the matter is. It requires reading, rereading, studying the fact. Then you get comprehension what exactly the facts of the case is, what question it involves, what is the substantial issue that is involved in the matter. Then find out the applicability of laws. Which are all the laws, statutes, rules, regulations, circulars, government orders, whatsoever may be, they are applicable here to the case on hand. That it favors them. There comes the skill of interpretation of law. How you read, stood into a conclusion. Yes, this right was at least, that is fine, the right is taken away, that is the law, therefore I prepare, say the memorial, I prefer appearing for petitioner. No. Under what process of law that right has now been taken away? whether the principles of due process are en masse, whether it affects any of my fundamental right, or whether some dilemma is there with respect to the facts alleged in a given case. So this analysis would give you, as an advocate, to which forum or which court or which authority you should approach. Several times as an advocate you find out such a situation where a person comes and says that he is facing some difficulty or problem. You will be in dilemma where to go, whether to the consumer forum or to an education appellate tribunal or to a civil court of the first instance or to a commissioner under a special statute or to the High Court under Article 226 or in some cases maybe to the Honorable Apex Court under Article 32. If you understand the facts of the case, find out the applicable law, notice what is the substantial question of law involved or what are the issues involved, and what is the scope of the law, what is the interpretation of the law in the given set of circumstances and facts of the case, you would determine, you would decide which forum to approach. Several of the cases for that matter, when you start practicing, you will come across only after you filing and the other party, the opponents or the respondents or the defendant, by whatever name you call, when they appear they say, this is not the appropriate forum whom the petitioner or the plaintiff has to approach. He has got remedy somewhere else. Somewhere else. Then you have to do some extra homework. How to see that, say, I am retained in the same forum, otherwise my petition would be dismissed. If you do this work in the beginning itself, then confidently you can say, yes, the jurisdiction is before this authority, this forum or this court only. Therefore, as an advocate, first point what you should understand is, to which court, authority or forum the matter or the dispute lies before, which has got jurisdiction, where to approach. In order to decide as to where to approach, as I said, all these previous, the basic exercises you have to do. Basic exercises you have to do. Then comes presenting the case in the form of pleadings. Once you are thorough with the facts, not just read the facts, you have studied the facts, collected or secured more information what you are required to collect from the party. The client may not say all the thing, or he may say something more what is expected to tell, or he may tell many things, lot of things, but leaving some important facts or the aspects which he was required to disclose before you. Therefore, as an advocate, first what you should do is, apart from listening to him, you should examine him, cross-examine him by putting questions, so that you elicit more details, more information required for you to proceed further in the matter, commencing from noticing what the actual facts are, what the questions involved, which are the laws that are applicable, which forum to approach. Then comes pleading, as I said. Your drafting must be in such a way, you should not left out anything, you should not tell in excess more than what is required. In the spirit of or in enthusiasm of you venturing to tell more things, you may stumble many ways. But there shall not be any omission. What is required, you cannot omit it, you should disclose it. But let it not give scope for interpreting differently, so that certain doubts would crept in automatically in your own pleading. That shouldn't happen. Therefore, drafting also plays very important role. Many of the students during their academic career, they ignore this aspect. We had one paper during our LLB days, drafting, pleading and conveyance, all put together 100 marks. probably that subject must be, even today in present syllabus also it must be there. And many people say in my days, in 1980s, used to ignore that, okay, one civil suit, take out a format, Order 7, Rule 1, plain, copy one format and write it something. One appeal, section 26 CPC, okay, do it. Or one writ jurisdiction, 226, what to be said precisely, take one format each, mug it up and write something. Absolutely not. That is most erroneous method. Unless you marshal facts, understand it correctly, get all the details, find out the question of a fact or the law involved, applicable laws, you cannot draft the pleading. Whether petition or a plaint or a complaint, by whatever name you call, you cannot draft it correctly, accurately. Same would be the case in the memorials also. So pleading must be perfect. Once you prepare pleading, then comes the issues which the court would frame. It all depends upon what pleading you have pleaded before the court in writing. The argument of the evidence follows later. The recording of evidence and the argument are subsequent events whose role would not be greater than pleadings. Pleadings are the foundation, basic foundation. You cannot improve a case either in evidence or in argument when it is not sound with or not accompanied with a healthy, complete pleading. Therefore, these stages you should recognize. Each stage you should put the required effort, and only then you can lead a good evidence, a good argument, and hope for a judgment in your favor. Therefore, one basic notion or one basic notion, if we have got anything, something like that, okay, let it be, we will engage a senior counsel, they will take care of, why should I bother? No. Even a senior most designated counsel also cannot alter or amend your pleading without due process of law. Therefore, at the entry level, what pleading you present before a court, that is very, very important in any forum, any court for that matter. It doesn't mean that, okay, pleading that is in the trial court, I practice directly in the high court, or I go to Supreme Court, I take advocate on record examination and I practice there. Why should I bother about this pleading? Don't be under this depression. In that regard, my sincere request to you is that commence your practicing in the trial court in the beginning. Completely devote your practice, dedication, commitment in the trial court practice for few years, 4 or 5 years in the beginning. If you are stationed or practicing in such a place where High Court is also located, yes, once in a week for selected matters, appear in High Court, but concentrate more on the trial court. It will enable you to lay down a strong foundation for your future career as an advocate. This is one aspect. The second, if any of you are under notion that, yes, I do my LLB here, then I do my masters, I try to secure a seat at United Kingdom or some other European country or America, and after doing my masters, I plan to settle abroad, or even if I return India, I practice on corporate side. Fine. Dream is good. Desire is good. But if everyone, all the 480 students of RVILS starts thinking who should take care of the litigants in the trial court, for that matter, understand one point, I have seen big banners, boards, a corporate advocate. He is specialized in intellectual property right, trademark, copyright, his service matter, education, labor. All at Bengaluru or Delhi or Mumbai, I practice there. No. They are only a small percentage compared to the total pendency of litigation in India. Anywhere in India you go, the needy people for justice are the common individuals who outnumbers in large multiplier compared to the corporate sector or big establishment. Who require the justice? Forefront are the people, the common man, the common individuals. It is for them primarily our aim, our desire, our motto must be to secure justice by practicing in the trial court. That's why I said, have practice in the trial court first. You get a strong foundation. Even if you tomorrow shift your practice to High Court or Supreme Court also, your trial court practice would be a strong backbone and support to you. And remember one thing, friends, till today in India, even their taluka court for justice, they cannot cater, they cannot arrange for the professional fees of the advocates or the court fee. They try to settle the matter among themselves, or they say, no, I am very poor, why should I say I don't have money, and several years I have to go around the court. Let it go. Say I have lost some 10,000 rupees, 20,000 rupees, 30,000 rupees, which is a very huge sum for me, but no other option, forget it. Millions and millions of people who are unable, very poor, to approach a court of law, though we call as an objective of our constitution justice for everyone. In order to achieve that objective of constitution, first we should focus on the common man. Common man. Therefore, trial court practice, apart from giving you a good foundation, a good knowledge about the profession, also will help lot number of people to get justice. So try to first commence your practice in the trial court, then you can shift and achieve excellence or expertise in any particular field of your choice and do better. It is not that only advocates, specialized advocates in particular field, only in High Court or Supreme Court alone are advocate. No. Advocate is advocate whether he practice in trial court or in Supreme Court. Each case is a test for every advocate, commencing from a trial court advocate up to a senior designated advocate at Supreme Court. Every case requires a hard work, dedication. Therefore, you, the students, particularly of the final year, the first batch, outgoing batch, have dreams, have desires, but think about the system, think about the society, think about the needy people, and design your design, the institution. All the best, and congratulating the institution for arranging such a nice, qualitative All India Moot Court competition, and also applauding for the institution's success in attaining higher ranks in the All India ranking level, and congratulating the management, the principal and the faculty and the staff for the purpose, and without ignoring the students whose involvement and whose dedication in the study has made the institution to grow up, and wishing you all the best. I conclude my speech. Thank you.
Privileged to introduce Honorable Justice, enrolled as an advocate on 8 September 1992. His Lordship was appointed as additional judge of the High Court of Karnataka and took oath on 11th November 2019. Honorable Justice R. Najraj gave up a seat that his lordship had secured in Bachelor of Engineering and opted for law. His lordship is a first-generation lawyer and began his career with Professor Janardana, senior counsel at New Delhi. Due to reasons beyond his control, his lordship returned back to Bangalore and established his independent practice, and during his career, his lordship has handled civil cases and cases involving constitutional issues at the High Court as well as the Supreme Court of India. His lordship served as the central government counsel for 3 terms and was later appointed as an additional advocate general. His lordship was appointed. His lordship took over. Your presence has indeed elevated our moot court competition, sir.
I request Honorable Justice to address the gathering. Sir, please.
I try to be as short as possible. Dear colleague, Mr. A.S. Vishnu Bharat, the Chairman of the Government Council, Mr. Anjana Reddy, the Principal of the Law College, all the teaching and non-teaching staff, my dear student friends. Male students, to give a big round of applause for the large number of female students in this college. I am not a disciplinarian. I would say that this is one of the golden moments of your life. This is the time when you will have to enjoy. And I don't know whether you like this or not, but I would say that this is a wonderful time for you people to enjoy really college life. Because as they say, just like babies, you will have to grow with a diaper once you get out of the institution. Once you graduate, you will be greenhorns in the institution. So it will start with a diaper, just like a baby does. So therefore, I would say that all students should enjoy life first in college. Because the administration may not like what I say, but at the end of it, yes, you should. And you should try to be street smart. Now, how do you achieve this? If you are street smart, that is the first character of a good lawyer. How do you become a street smart? Go to the market, go to an industry, go to a place where people are striking, go to a government office with somebody who has got a petition. You will know what is the strife, the struggle that people are facing. After all, you are going into the stream or the mainstream in a few years from now. So you should equip yourself with the knowledge as to what are the problems faced by these people. It's only when you know the problems of these people that you will be able to fight. And once you are street smart, I can assure you, no court can just ignore whatever you say. Because everything that you would have formulated would have been thought out after a great churning in your own mind. So I would exhort all of you to go out, meet people, meet new people. See, these new people are going to be your clients one day or the other. With the conditions, some people could be comfortably placed. Many of them are struggling. So you can make a decision whether you want to serve those people who are comfortable, you want to serve those people who are struggling. It's a choice that you people will have to make. At times, I feel that a person without rights is like a mobile without a SIM card. Just imagine a man is deprived of his rights, he is arrested for no fault of his, he cannot go to the courts, he doesn't have the wherewithal to go to the courts. Just imagine, a person is arrested by the police, no charges or some charges are framed against him which are not justified, but still he cannot go to the court due to various circumstances. Put yourself into his shoes. Just put yourself into his shoes and just imagine you're spending a day's time in a police station for something that you have not done. Just imagine the strife that that person could be undergoing. So therefore, I would say that each one of you is a champion of the cause of public justice. Each one of you will have to fight for other people's cause. Maybe in the process you get paid, you get enriched, all those things, these are fringe benefits. But the ultimate goal will be to protect or assure the rights of individuals. This is the biggest endeavor of any lawyer. If a client ultimately comes to you and says, he falls at your feet, he sheds tears, he and his family will come, they will say, sir, you have protected me, you have protected my family, this is the greatest thing that you can ever do to any, and you will be compared to God. Can you imagine a human being being compared to God? These things have happened in our lives. So I would tell everybody that please look out for things. There are many things where you can help. And one of the finest requirements of a lawyer, as Professor Dr. Justice Prabhakar Shastri put it to you, it is the art of storytelling. Please learn the art of storytelling. I hope everybody knows Kannada here. Just imagine if I were to tell you, Anjaneya, he went to Sri Lanka to bring Sita, and Ravana was killed. The story ends, does it end here? What did you make out of it? On the contrary, if you were to say, ಅಯೋಧ್ಯ ಅಂತ ಒಂದು ರಾಜ್ಯ ಇತ್ತಂತೆ, ರಾಜ್ಯದಲ್ಲೊಬ್ಬ ದಶರಥ ಅಂತ ಮಹಾರಾಜ ಇದ್ದಂತೆ, ಅವನು 3 ಜನ ಹೆಂಡತಿರಿದ್ರಂತೆ ಅಂತ ಶುರು ಮಾಡಿದ್ರೆ, just see the difference. So you should learn the art of storytelling. That is when you start comprehending the facts. You will know what exactly to be put in context. What should be told first, what should be told next, what should be told and what shouldn't be told. These are some things that you will start learning. So therefore, try to visualize, or if possible, wherever possible, try to hone the skill of storytelling. The other requirement of a lawyer is, many of you might not have participated in the Moot court, maybe because of stage fear, maybe because of not willing to participate. But one thing I will tell all of you, you will have to end up in the court one day or the other. You will have to come before us, you will have to plead before us. So therefore, please fight this stage fear by getting onto the stage. There is no other way, there is no other shortcut. If you want to excel in the art of public speaking, first come onto the stage. Make some preliminary work, preliminary study, get some facts, get some points, come to the stage, blurt out whatever you can. You can fall in error once, you may lose the second time, the third time, the fourth time, the fifth time when you come onto the stage. I'm pretty sure that you would have overcome the stage fear. The first stage you would have already overcome. So, one or two qualities which I mentioned, at least I have
I have inculcated that in myself, so I can tell you with a lot of conviction that you also can do this. Today we have come for this national level moot court competition. It was a wonderful moment to judge the finals. As rightly put by my learned brother, the competition was very tough. In fact, we were worried, going by the way these lawyers argued, someday they will give us a scare in the court also. So I wish all the best to all the participants. Wish you good luck. Thank you.
Thank you, sir, for your thought-provoking words and for telling us the importance of storytelling with the example of Ramayana. It was an honor to hear you. It's a privilege to have with us Honorable Mr. Justice C.M. Punacha, Judge High Court of Karnataka, Bengaluru, as the guest of honor of the day. I invite Mr. Anirudh P. Ramesh, student of 5th semester BLLB, to introduce sir to the gathering.
Ladies and gentlemen, today I have the honor of introducing you to Honorable Mr. Justice C.M. Punacha, a distinguished member of the legal community who has made significant contribution to the field of law. Justice Punacha was born on April 6, 1974 to late Sri C.M. Monappa and Srimati Shaila Monappa. Justice Punacha completed his schooling at Baldwin's Boys High School, Bangalore, between the years 1980 and 1990. He pursued his pre-university at Vijaya College, Bangalore, and went to study at the University Law College, Bangalore, in the year 1992. After completing law in 1997, Justice Punacha enrolled as an advocate in the year 1998 and joined the chambers of Mr. S.K.V. Chalapati, now senior advocate, and later with his father C.M. Monappa, advocate. In 2001, Justice Punacha co-founded a law firm called LexisPlexis, along with two of his college mates. Since then, he has practiced as an advocate for over 20 years and has appeared before various forums including courts, tribunals, commissions, high courts, and the Supreme Court of India. He has represented various state and central government bodies, banks, insurance companies, and other institutions in various courts and tribunals, apart from representing individuals in varied kinds of litigations. He has been on the panel of insurance companies and banks and dealt with insurance-related matters such as marine, fire, professional indemnity, motor vehicle, and medical, among others. Justice Punacha has also rendered advice and opinion on various issues including intellectual property, shareholding patterns, SEBI guidelines and regulations, issues relating to cyber laws, property laws, and economic offences. He has handled significant numbers of arbitrations, including one pertaining to International Chamber of Commerce arbitration, etc. Justice Punacha has been empaneled with the Karnataka State Legal Service Authority and the High Court of Karnataka since 2015. He was appointed as Additional Advocate General, High Court of Karnataka in August 2020. His remarkable dedication and work ethic led to his appointment as an additional judge of the Honorable High Court of Karnataka and sworn in on June 13, 2022. In addition to his legal expertise, Justice Punacha has pursued various other academic interests. He completed a diploma in Entrepreneurship Administration and Business Laws at the National University of Juridical Sciences, Kolkata, in 2016-17, as well as attended a course in Private International Law at the Hague Institute of International Law, Netherlands, in the year 2016. He has also participated as a speaker at various seminars on different branches of law. Justice Punacha is not just an accomplished lawyer and judge, but also an individual with diverse interests. He is an avid trekker and a marathoner, having participated in various marathons all over the country. Justice Punacha is a role model for aspiring lawyers and judges with his exceptional legal skills, academic achievements, and passion for continuous learning and personal growth. It is indeed an honor to have you with us today, sir. Thank you.
Thank you, Anirudh. I now request Honorable Mr. Justice C.M. Punacha to address the gathering.
Good evening, everyone. Coming as one of the last speakers is always a tough task. When the attention span of the audience has probably reached the fag end. Anyway, let's see what best can be done about it. Justice Dr. Prabhakar Shastri, my esteemed senior colleagues, Justice R. Nathraj, Dr. Vishnu Bharat, Chairman of the Governing Council and Trustee, Dr. Anjana Reddy, the Principal, the staff and the non-teaching staff of the institution, and my dear friends. Firstly, I would like to compliment all the participants of this All India Moot Court competition. Participating in a competition like this is the first step. Secondly, the effort that each of you all have put in to go through this competition. Finally, don't get bogged down by the result of the competition, because the experiences that you all learn and the takeaway that you all will have in each of these competitions you all participate, finally, that is what matters. And it is these experiences which will add to your learning curve as you enter the profession. Coming to judge this competition brought back memories of when I participated in competitions like this as a mooter. It is always a thrilling experience. One thing I would like to probably compliment each of you all is that you all have chosen an exciting profession. The experiences that you will encounter as you go ahead in this profession are varied. One suggestion which I would like to give you, my young friends, is participate in as many co-curricular activities that come by you, and ensure that you capitalize on every opportunity that you get. Also, apart from competitions like these and various other speaking events, because that's one of the major skills that you will require as a professional, because how much ever you read, how much ever you know, finally in a profession like this, it is how you articulate what you know is finally what matters. So try to do like Brother Nathraj said, you have to overcome the fear of speaking or public speaking or whatever you may call it, and the only way to do it is to participate in competitions like these. Secondly, another, probably you can call it a piece of advice for an older friend, is that try and do various internships during your stint as a student. And when you do these internships, try and do it in different branches. Try and do one stint with, say, a criminal lawyer. Try and do one with a civil lawyer. And like Justice Prabhakar Shastri said, you will get the ground level experience when you start from the trial court. I would suggest you also do an internship at, say, a law firm or in a commercial field, because each of those internships give you a different learning curve. And the idea of these internships is, when you complete your course, you are in a better position to decide in what manner you would like to take forward your profession. One of the reasons why you'll need to do these internships is to get the exposure because then you all will realize how law is applied practically. When you come back to college and when you are taught the theory of the law, and when you go out to the field or practically to courts, you will understand how the system works. And please understand one thing, when you go out to do these internships, there's no teaching, nobody's going to teach you, but learning will never end. It is not the knowledge, you will always be a student of law. Once you get into practice, whether you hold a judicial office or whatever it is, you will always be a student of law. But how law is applied practically and how this application of law impacts the citizen of this country and how the law is used to solve their problems, that experience you will get as a first hand. And while you do these internships, you learn various other things. For example, when I was a lawyer, we had an intern who was one of the students in the law colleges and come and given a research item for him. And then he finally came up with the end of with the results and he had given a note. And I was just going through the note with him. And he had quoted from certain judgments. So I was quite impressed with the judgment that he had quoted from. And on a hunch, I asked him, did you read that judgment? And he was a little surprised. So he asked me, so you mean to say the whole judgment? I said, then how did you get this piece? And this is exactly the hunch I had. As usual, the tech-savvy generation Googled it or got into another legal website, got a line which they were impressed with and put it on the paper and gave it. Having absolutely no idea in what context it is used or in what fact situation it is used. So one of the first things that I had to respond to him is, see, when a bench of 3 or 5 or 2, whatever, learned judges have written a judgment. Forget about the common man. Don't you think it's incumbent on a lawyer or a law student to at least read it? And without reading it, what would you understand out of what is laid down as the law? See, these are the practical experiences that you will get. The other aspect or a suggestion which will hold you in good stead as you get into the profession is have a fair amount, cultivate a reading habit. You can read varied aspects. Also, when you cultivate a reading habit, there are a few areas of importance like where the Supreme Court has settled the law. Now, for example, the constitutional validity of the death sentence. Now, when you ask anyone whether a death sentence is good or bad, everybody has an opinion about it. But please understand, when you are a law student and you are asked an opinion about these things, your opinion should be somehow different from, say, a student of sociology or a student of history. People expect you to know the law. People expect you that when you tell your opinion, that you will tell something different than what another person has. So you will always find these marquee judgments on settled positions, like for example the Nas Foundation case which 377 was struck down, or the death penalty. You will have innumerable areas of law like that. So please cultivate it as a reading habit, try and understand the base of it, so that when you participate in, say, a discussion or in whatever field, that reading habit will never fail you. I can assure you that. So please use all opportunities that you can get, because every opportunity will give you a different experience. Truly, like Brother Justice Nataraj said, student life is indeed one of the golden periods of one's life, and you will always be required to enter the profession one day, and whether you choose in which area of law that you would like to practice, and if you choose litigation, in what area of it you will practice, it's all up to an individual. But I can tell you probably a little biased in my opinion, that there can be no feel more thrilling than the litigation of law. That gives you the actual high when you practice. When you take up a case of an individual who you feel is a deprived person of his rights, and you pursue it in a court of law, and you succeed, apart from all other aspects of how much money you make, and those are all incidental aspects, the satisfaction that you feel is something unparalleled. So with these few words, I wouldn't want to take more time of yours. I would like to firstly thank the organizers for inviting me to this event and giving me the opportunity to be amongst you all. I compliment the organizers and the institution for organizing such an event on an all India basis. I once again congratulate all the participants who participate in this event and wish you all the very best in your future. Thank you.
Thank you, sir, for sharing with students the different steps that they have to take which would help them in the profession. That is the importance of participation and importance of internships. We have our very own CA Dr. A.S. Vishnu Bharat, Chairman, Governing Council, RB Institute of Legal Studies, and Trustee, RSST, presiding over the occasion. I request Ms. Srishti Chadar, student 5th semester BBA LLB, to introduce sir.
It is my privilege to introduce the president of today's program, CA Dr. Vishnu Bharat sir. Sir is a transformational leader with a rare blend of an educationalist, social activist and humanist. He hails from a well-known and respected family. Sir is a practicing senior chartered accountant from the past 47 years. At present, Sir has occupied various positions in many organizations. Some of them are President of Vasavi Veda Nidhi Trust, Sanskrit School, Karnataka Service Apartments Providers Association, Vice President of APS Education Trust, Bengaluru, Executive President of Karnataka Federation of United Nations, UNESCO, Director of Can Bank Factories, subsidiary of Canara Bank, Chairman of RV Public School, RV Institute of Legal Studies, Education Committee of FKCCI, Trustee of RSST, RV University, Bengaluru, Welfare Trust of GMR Infra, and Donor Trustee of Vasari Sarada Ladies Hostel. Sir was also a Managing Committee member of FKCCI from the past 18 years. Sir has a wide experience in income tax, banks audit, and advisor for many banks, including the earlier Vaisya Bank. Sir has been awarded for his social service rendered to the society, such as Honorable Doctorate for Social Service and Contribution to Society received from Mangalore University, Nadaprabhu Kempegowda Award by VBMP, Rashtriya Udyog Award from International Economic Forum, Vasava Siri Award from Vaisya Community Association, Kannada Siri Award from Kannada Sahitya Parishad, and so on. Sir has authored 45 books, both in English and Kannada. A few of them are Life is Like a Journey on a Train. This book is recognized by international publisher and made available in 158 countries. Personal Guide to Income Tax published by FKCCI, Kannadave Nitya, Kannadave Satya, and so on. Sir has travelled all over the world and also is a member of Red Cross Society. We are honoured to have you on this occasion, sir. Thank you.
Thank you, Srishti. I request CA Dr. A.S. Vishnu Bharat sir to deliver the presidential address.
Very good evening to most respected lordships, Justice Prabhakar Shastri, Justice R. Nataraj, Justice Punacha, and all the faculty members who is putting their whole and soul shaping our budding advocates and you budding advocates. A very good evening to all of you, and it is a red letter day of our RV legal studies. This is the day where 3 honorable judges of High Court have come. This is the day you remember for your life. You will be representing before them. Today, I had the fortune to witness the Moot court, and it was a writ petition before the Supreme Court. When the honorable justices were sitting there, I was thinking and praying that they should be the Supreme Court judges very shortly at this one. I'm sure they will be with the caliber they have. So you, the budding advocates, have great future. The economy is going in such a fast pace of manner, and naturally there will be growth in the legal this one, and you will also have ample opportunities. All that you have to do, put your whole and soul and try to come out as early as possible from the law college, go for the practice and appear before the courts. So this is my 50th year of chartered accountancy. I know when I win the case, when I get my client relief from the things burden, how much satisfaction, more than him I get satisfaction. That is the thing you are going to get as a professional. You will have wonderful opportunities, the God-given gift to you to be in the legal this one, you have wonderful scope. I was only looking at my profession as this one. Today, after looking at the arguments and this, I know this legal this one is more challenging, and how much you take it, that much you have the scope. So that is the things you have before you. So I get no such opportunities to put my prayers to the honorable judges. I had occasion to visit the courts. Sir, what we are following after 76 years of our independence, the good old British way which they have left it, we are still following it. It is called Obi Rayana Kaladu. Obi Raya andre gotta nimage old British rule. Obi Raya anta old British rule. Adike Obi Raya anta bandittu. Avaru bittu hogidina ನಾವು ಇನ್ನೂ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. If you look into the civil courts and district court, it is just like a fish market. The petitioner, the respondent, not one, all the respondents, their advocates, his advocate, everybody will come there, and the judge most unfortunately have to give the date because of one or other reason. Either the advocate has not come, or the litigant has not come, or the petitioner has not come. For one or other reason, a number of cases posted are heavy. Everything cannot be taken. The registrar could, analyze and fix the dates, and the time given to the advocate be limited so that he will not drag on and on and on. An endless number of opportunities and time is given to him to put up his case. And that if it happens in one day is over, but it happens in number of days. And such as the system which we are still following it. And the culprit is not punished. So that is my observation. Just to drag on, just to harass the party, he will try to put the case and drag on and on. After civil court, go to high court to Supreme Court, because he won't have to pay advocate fees, but the amount what he is saving out of the interest or because the indexation, inflation and other things, so he is going to jolly well pay at the end of the day what he has to pay. The culprit is not punished. I'm sure that it will come to you there. You will all be elevated, and you will be the Chief Justice, and you will be Supreme Court judges. So kindly look into that. The new, our age-old principles, the Panchayat Raj, the kings, how they used to take the decision. With the experience of them, they know who is the guilty, who is the culprit, who is the victim. So they can do it, but the procedure, long procedures which has to be there, it takes time. And you are Kannadal Gade there. Geddavanu sota, sotavanu satta. So justice delayed is justice denied. But that should not happen. At the same time, there should not be guilty, should not, the victim should not be punished. So I'm sure that you will balance out. I'm not in the legal this one to frame it, but I can only tell as a stranger my experience, my feelings. So this is the institution. Within the short span of 4 years, it has grown, all thanks to Mr. Anjan Reddy and his entire team who have dedicated I'm the proud chairman of this legal studies in the board. I confidently and go to the board and tell them what is happening, and this is the occasion which my entire board will relish it, and they will all thank you for the wonderful evening you have spent with us. It may be one evening for you, but all of them will remember for life. Just such is the thing there. I sincerely thank all of you, and I'm sure I'm equally waiting for the results. None of us know, including the justices. They have given independent decisions. They have been tabulated. I do not know who is the winner of the case will be the winner, or the person who has argued the case will be the winner. I'm just equally waiting for that announcement of results. I'm sure all of you will be also looking for it. Thank you. Very good evening.
Thank you, sir, for your address. If you believe in yourself and have dedication and pride and never quit, you'll be a winner. The price of victory is high, but so are the rewards. Moving to the most awaited program of prize distribution, I invite Ms. Vinuta D.N., Assistant Professor of Law, to announce the names of achievers, and I request the dignitaries to do the needful.
Good evening to all the dignitaries. Today, I have been privileged to announce the results of First All India Moot Court Competition 2020-23 organized by RV Institute of Legal Studies. Best Memorial Team Code RVAIM 05 Bangalore Institute of Legal Studies Shreyas, Varsha and Vishwan. I request Honorable Mr. Justice C.M. Punacha sir, Judge, High Court of Karnataka, to give away the trophy and the cash prize of 5,000 rupees. Thank you, sir. Best Mooter Team Code RVAIM 12. College name SDM Law College, Mangaluru. Name Nitya. I'm so sorry. The best Mooter Team Code RVAIM 11, Shastra School of Law. I request Honorable Dr. Justice H.P. Prabhakara Shastri sir, Judge, High Court of Karnataka, to give away the trophy and thank you, sir. Best Researcher Team Code RVAIM 12, name Niharika, College, SDM Law College, Mangaluru. I request Honorable Mr. Justice R. Natran sir, Judge, High Court of Karnataka, to give away the trophy and the cash prize of rupees 5,000. you, sir. The most awaited moment, the winner of RVILS First All India Moot Court Competition goes to RVAIM 23 School of Excellency in Law, Dr. Ambedkar University, Chennai, Maheshwaran Kirtiba Kiran. I request all the dignitaries to give away the memento and cash prize of 20,000 rupees. Runner-up team of RVILS First All India Moot Court Competition goes to RVAIM Team Code 12 SDM Law College, Mangalore. I request all the dignitaries to give away the trophies and the cash prize of rupees 10,000.
Come.
Congratulations to all the participants and the winners. Thank you all.
Thank you, ma'am. We congratulate all the winners and wish them all the luck for their future endeavors. I thank the dignitaries for doing the needful. It is said that if the only prayer you ever say in your entire life is thank you, it would be enough. I request Ms. Bhavna C., Assistant Professor of Law, to propose a vote of thanks.
A very good evening to all. Thanking is a true measure of humbleness. I feel honored and privileged to get the opportunity to propose a vote of thanks on this special occasion.
Despite being swamped in busy schedules, honorable judges of the High Court have taken time out and aided the students in their pursuit to seek knowledge for which we, as an institution, are eternally grateful. I will express my sincere regards to the chief guest, Honorable Justice Dr. H.P. Prabhakar Shastri of today's ceremony, as his Lordship's presence and deliberation has enriched us immensely. Thank you, sir. I request our Chairman Dr. C.A.S. Vishnu Bharat sir and Principal sir to felicitate our chief guest. Thank you, sir. I express my earnest regards to our guest of honor, Honorable Justice R. Natraj, as His Lordship gracious presence has filled us with scholarly thoughts. Thank you, sir. I request the Chairman and Principal sir to felicitate our guest of honor. Thank you, sir. I express my heartfelt regards to our guest of honor, Honorable Justice C.M. Punacha, whose presence has elevated our event. Thank you, sir. I request the Chairman and Principal sir to felicitate our guest. Thank you, sir. Undoubtedly, the participants have got a tremendous learning platform when such enlightened judges have judged our competition. Thank you, sir. I would thank Dr. C.A.S. Vishnu Bharat sir, the Chairman Governing Council of RBILS and Trustee of RSST, for being a part of this event and sharing his views with us. Thank you, sir. I request our Principal sir to present a token of gratitude. Without the able support and guidance of our principal, Dr. Anjana Reddy KR, our principal believes in collective leadership, which provides the students of this college with an ocean of opportunities to learn. Thank you, sir. I request Ashmita, Assistant Professor of Law, to present a token of gratitude. Thank you, ma'am. I thank our management who have supported us in all possible ways to organize this competition. I thank all our eminent personalities from academia and bar who helped us in judging this competition from preliminary rounds to semi-final rounds. I would like to convey my gratitude to faculty, students of other institutions and parents gathered here for taking time to join us today and for assisting us in making this ceremony a success. And I also thank all the participants, the winners as well as all the participants of this competition. All the best for your future endeavors. The syncopation of the entire Moot Court competition has been the participants who are filled with energy and enthusiasm. I express my thankfulness to all of them once again. It isn't something that happens tonight. Weeks ago, the wheels began to turn. We have been lucky enough to have the support of a team of proactive and devoted faculty coordinators and all the fellow faculties of us, especially the faculty coordinators of First All India Moot Court Competition, Mr. Arunes, Ms. Safalya Wagle and Ms. Maitra Validi. I thank the press and media and administrative staff for their assistance. Last but most importantly, all my dear student volunteers, I heartily thank you all for your constant support and guidance, without which this wouldn't have happened. Thank you once again. I once again thank all the members of this gathering for taking the valuable time out and attending to today's event. Thank you. Good day.
Thank you, ma'am. It wouldn't end if we wouldn't thank you, because you everyone to kindly rise for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
With the permission of the dignitaries, I request teaching and non-teaching staff to join us on the stage for a group photo. And also an announcement for the participants. You will be issued participation certificates and mementos